we can start. We are connected. Yes. Good morning, colleagues, and good morning to all our attendees. It's now 10:02. I think we can start right now. We do have 447, and the number is increasing of our attendees. We can start, but just to lay out some of the things that we'll be doing. All CPD points will be allocated to an attendee who attend for more than 3 hours. It's a 4-hour program, so you need to attend more than 3 hours. And also, we are going to flight some questions because CPD board notice said that it must be an interactive. So we are going to flight some questions, and you need to answer those questions when they are flighted on your computer. But for now, let me hand over to Brenda so that she can do the introduction, and then we start. We will start the process with Mr. Decker. Thank you very much. Over to you, Brenda.
Thank you very much, Mr. Munenzi. Greetings to all the professionals. My name is Ms. Brenda Hake, and I am the Stakeholder Relations Officer at SACAP. We firstly wish to welcome everyone. We firstly wish to welcome everyone to the second session of the webinar on referrals. The first session was held on the 17th of April, 2023. These sessions are meant to equip professionals to submit plans that are of higher quality to better serve the public efficiently and on time. The first session mostly touched on SPLUMA and the National Building Regulations, requirements of plan submission. Today's session will be based on Form 1 to 4 of SANS10400A, competent persons, power of attorney. Please pay attention to Form 1, which touches mostly on making the declaration on how the professionals comply with all the requirements or regulations pertaining to the submissions of plans, of which obviously Mr. Decker will go through the presentation. We encourage your full participation and fruitful engagement on understanding how, as a professional, you should meet all requirements for purposes of submitting plans of higher quality. Notwithstanding what I've just said, please note that only attendees joining us on Zoom will be eligible for CPD points allocation. Facebook attendees will not receive CPD points. I will now hand over to Mr. Decker to take us through the presentation. Thank you very much. Over to you, Mr. Decker.
Okay, thank you, Brenda. I just want to have sound switch off here before I can talk. Otherwise, I'll hear myself in echo. So if you can just give us 5 seconds for a technical thing to be sorted out.
Yes, you can go ahead now. It's fine.
Okay, I'm still hearing the other TV, which causing an echo.
Okay. Just give me a sec. Yes, Mr. Decker, you can go ahead.
Okay, thank you very much for that. I'm using a mic, as you can see, in front of my face, so that because it's directional and it cuts out all background sounds and stuff like that, so that you can hear me better. Before I start, I'm just going to switch off my video, and then I'm going to share my screen so that you can see what's happening. Okay, there we are. And I welcome then you to the second session. And thank you then also for SACA for the opportunity then to present it to the architectural professionals. And what's in store for you today is that we're going to look at, and I've switched around the order a little bit so that we have a little bit of information before we actually go to the forms. So I will first touch on the power of attorney. A lot of us being agents of the client do have automatically then power of attorney, but in certain cases, power of attorney, you cannot do so because of conflict of interest, and we will quickly discuss that then this morning. Then we will move over to competent persons, and I've got a great discussion on that, being involved in the technical committee at SAPS as well, and where the standards currently, or some of the standards currently, define competent persons. I will also enlighten you about new developments actually there. And now we actually deal with that at the SABS for that matter. And also come back to the SACP code of SACP competencies, and I'll also address a little bit of the EXA competencies as published in their identification of engineering work policy. Then obviously we will go to Form 1, and I will do a rather in-depth example of Form 1, show what is going on there, etc. And then we will move to Form 2, Form 3, and to Form 4. So let's start then with the first one, which is then the power of attorney. So the first question that we can ask is, what is a power of attorney? I know we sign sometimes quite a number of these so-called power of attorneys, but do we actually know what we are signing, and what are the legal implications if we have signed such a power of attorney? Now, in terms of the South African law, a person may not act on behalf of another unless he is authorized to do so. So you cannot even act on behalf of your client, and that is where the client professional agreement becomes so important, because the client professional agreement, in many cases, in most of the cases, allow you then to act as the agent of the client. With other words, you've got certain rights due to the agreement that you have signed, and you are binding the client by your decisions due to the fact that you are an agent of the client, but you cannot alter the scope of a contract which the client has entered into, the contract between you and the client, as well as in the building contract between the contractor and the client. So we just have to understand that. And again, here you can see the importance of the client professional agreement. Without the client professional agreement in place, maybe just a quote or a fee proposal, etc., you cannot act as the agent of the client because you haven't got the authorization to do so. That authorization, as I've said, normally comes then through the agreement that we signed. Now, and as such, a power of attorney is then a formal instrument by which then authority is conferred from the principal, that is now the person giving the authority to act on his or her behalf, that's our client, to the agent. In that case, it will be the architectural professional. With other words, the person acting on behalf then of the principal. Now, when will we need a power of attorney, and what can we, and when we can, and who can be appointed then as such an agent? Now, for reasons of practicality, it is often necessary for someone to entrust the management of their affairs and property to another person. When we deal with local authorities, we sometimes have to sign documentation to get access to previous plans drawn and submitted to a local authority. We might need to have access to title deeds. We might have to have access to surveyor general diagrams or to other information that is normally only provided by local authorities and other authorities to the owner of that property. So if we've got then the power of attorney, it means then that we've got the authorization then of that owner to do so, so that we do not every time have to run back to our client and say, listen, I need this, you have to go there and sign it so that I can get the document. So that is one of the reasons why power of attorney in for architectural work is so important, so that we can then get the documentation and all the information needed, what is in many cases only provided to the owner of the property. And that is where POPI then also, the POPI Act, the Private Information Protection, the Protection of Private Information Act come into play. So we can get an information that is only earmarked for the owner to see if he gives us then that power of attorney to do so. Now, any person over the age of 18 can be granted such power of attorney by the principal, provided that the agent is both competent and trustworthy to make financial and legal decisions. And that's what I've said earlier, and I'm just going to be a little bit further than just the normal power of attorney to get a document from a local authority. When we are appointed as the principal agent to deal with stage 5 and 6, our actions bind the client. We sign, for instance, what they call it, payment certificates. So, and that payment certificate is a legal document and it binds the client. So we make financial and legal decisions on behalf of the client, which is binding him. There are obviously decisions that we cannot make by altering with others, by altering contracts or the wording of contracts, etc. But if something is described in a contract and we as an agent then we have got the right to act on behalf of the client and bind the client in doing so, then that will be then okay. So what powers can be conferred by a power of attorney? The powers which are conferred by a power of attorney can either be general or special powers. Now, in terms of a general power of attorney, a principal would be able to authorize the agent to conduct his or her business or manage his or her affairs without any reservation, or to perform a wide range of acts as set out in the power of attorney. In terms of special power of attorney, a person would be authorized to perform a specific act, such as signing a sale agreement or even opening a bank account. Just a word of caution there, as you can see there, that is a special power of attorney. So it's important to note then that the authority of the agent is embodied in the power of attorney, whether it be then a general power of attorney or a specific power of attorney. In other words, it is the formal document, like the agreement between us and the client, etc., which will then determine the scope and the extent of the agent's authorization. And sometimes we have to sign another document so that we don't have to go with the whole agreement between us and the client to a local authority to obtain certain information, but there are then certain documentation that we can sign and the owner can sign, which grant us then that power of attorney to get that information as the agent on behalf of the client. So the agent's authority is restricted to those powers which are conferred by the power of attorney and incidental to the performance thereof. Now, there are prescribed formalities. And what are these prescribed formalities then when it comes to a power of attorney? A power of attorney can be granted informally and even verbally, as there are no general prescribed formalities with which it needs to comply. But as we know that when we deal with clients and we deal with legal matters, building plan submissions and all those kind of things, it is better to have it in writing. I think it's also required in terms of our code of conduct and the way that we run our business, not just to rely on verbal power of attorneys, because the problem here is how are you going to prove that you indeed have that power of attorney from the client? So when a power of attorney is required for a specific purpose, certain formalities are then prescribed. Now, one of them, and this goes a little bit beyond what we will normally do, but just to describe what is a specific or a certain formality for which we then have to have a power of attorney, and where formalities then needs to be in place. In terms of Section 95 of the Deeds Registries Act, if you ever have read through a title deed, you would have seen that there's a whole declaration of the person that actually submitted to the deeds registrar of deeds, and all his details are there, and he declared how he got the power of attorney then to act on behalf of the person who's selling and the person who's buying, and then obviously in then acting as the agent, the conveyancer then who actually then registered the deeds at the deeds office. So a power of attorney in terms of the Deeds Registries Act, authorizing the performance of certain acts in the deeds registry, must be attested by two competent witnesses. It must be attested by a magistrate, a justice of the peace, a commissioner on oath, or notary public. So you either have to have two competent witnesses stating that, yes, it's true, this guy has got it, or it must be done by going to a magistrate, to a justice of the peace, to commissioner of oath, or a notary public. With other words, anybody that's been granted the legal permission then to certify that you indeed has got this permission. So there's a legal formality in place there. Now, if a client gives you a power of attorney, does it lapse? And obviously it will lapse if your contract comes to an end. But the requirement that a principal must have a contractual capacity at the time when authority is granted to the agent has the implication that should the status of the principal change with regards to the power to conclude juristic acts, the authority conferred upon the agent will lapse. With other words, if your client passed away and yet have been granted power of attorney, that's one of the things then that immediately the power of attorney attorney will then obviously come to an end on the passing away of such a client. So similarly, a power of attorney granted by a person during their lifetime, as I've said now, will become null and void upon their death. It is only a lawfully appointed executor who is then permitted to deal with the estate of a deceased person. And I had in the past a few queries regarding that. What about my client has passed away? Can I still submit the building plans, etc., because I've got the power of attorney to act on his behalf? And here you've got the answer then, no. You can only do so on instruction then of the executor, of the appointed executor of the estate of the deceased. Let's come then to the architectural professional and look at the architectural service, professional service that we render that grant us then, through the agreement that we've got with our client, then such power of attorney. So our client appoints the architectural professional to provide a service for a project as contemplated by the Architectural Profession Act, the National Building Regulations and Building Standards Act 103 of 1977 as amended, as well as the South African National Standards, that is in most cases then the SANS 10400 series and any other applicable legislation. Pardon me just for a second. Apologies for that, but your voice sometimes decide to go to another place. That's where you want to have it. So the architectural professional accepts the appointment, and in many cases then through that appointment and the legal documentation, that is the contract that is required in terms of our code of conduct, then to exercise reasonable professional skill, care, diligence in the performance of its obligations. And one of those obligations then will be then to act as the agent of the client. And obviously we do that then for a fee as defined in a written agreement. Now, when you've got power of attorney, it will be limited to issues where it, in our case then, and that's how I see it, and it might be a personal interpretation, but in many cases, law requires the owner to sign a document. And like, for instance, the National Building Regulations and Standards Act of 1977 required the signature of the owner on a building plan application, as well as on the building plan, etc. The building regulations through SANS10400A Form 1 require the owner to sign a declaration. Now, in those cases, I do not believe that we've got the power of attorney to sign on behalf of the client, because there's a legal requirement that it must be the client to sign. And where it comes, especially then to Form 1 and also Form 2, the client also makes a declaration. And I will deal with it, what is a declaration, a little bit later. And we also, in the following section, also make a declaration. So you can't make a declaration on behalf of the client, because that will be then conflict of interest, because you're also required to make a declaration on the same piece of paper. So where it comes then to Form 1 and Form 2, the client needs to do so. And if the client can't do so, everybody, the Act do allow for anybody else, like his attorney, his estate agent, or something like that, who is not involved in the actual performance of the service that's been rendered, then to act as his or her attorney. But we cannot sign a Form 1 or a Form 2 on behalf of our client, or any other documentation where it comes to the submission of building plans, where we also are required to make declarations or countersign it in our capacity as the agent, as we then there would be then a conflict of interest. Can't think of an example in general life now, but you know, if let's say you go and buy a car, and you sign the agreement there, a financial agreement between you and the bank, you are not allowed to sign on behalf of the bank, and then on behalf of yourself, but even if the bank gives you power of attorney, because clearly there will be a conflict of interest. And that is my interpretation then when it comes to Forms 1 and 2 and other documentation in terms of the National Building Regulations. So our power of attorney restricts us basically to getting information for the execution of our duties, which normally would require the owner to give permission that that information has been provided to us, like copies of building plans, etc. But it cannot actually go further than that, where there might be then a conflict of interest, where the client needs to be aware of certain steps that were taken, etc. And otherwise we can sign all the forms if we've got power of attorney. The client don't even see the building plans, and believe me, that happens. And then it gets approved, and then the client only find out what has been done, and then the problems starts. So just be very careful then, if you've got power of attorney, that when you sign on behalf of the client as an agent, because you are binding him, that it is not done so where there's a conflict of interest. With other words, where you've also got due to your appointment, then a personal interest in what you then sign. Okay, I'm going to deal next with competent persons, and I think after that, this session, competent persons, then we can take some questions before we actually go to the forms then. Now, competent persons, yeah, it's always an issue because of misinterpretation. Who declares you to be competent? And there's also a misinterpretation of what is written in the National Building Regulations when it comes to competent persons. And unfortunately, in the 2010-2011 editions of the SANS10400 series, an error crept in, and I think that came from the time when the SABS was still had the authority to the regulatory authority as well, which was taken away from them in 2008 by the establishment of the NRCS Act. That at that stage, the standards writers did not see any problem of writing a regulatory requirement into the standard. Today, the norm of standards writing, you can go, it's a free document on the SABS website if you want to go and read through that, what can be in a standard and what cannot be in a standard. A standard cannot contain voluntary regulatory requirements. A standard is a voluntary document. I think I've explained last time the fact that you declare in Form 1, and that's what we're going to deal with later on, that this is the way that you're going to use a certain SANS10400 standard to satisfy the building regulations. Your action in satisfying the building regulations, you make the use then of the standard compulsory, but the standard remains a voluntary document. And therefore a standard cannot contain a regulatory requirement, and a standard is not a regulation. It provides you with a set of rules. I know in the industry, we talk quite often about the SANS regulations. Please refrain from doing that because there is nothing like a SANS regulation. A SANS is a South African national standard. That's what SANS stands for. The building regulations is published in the Government Gazette, signed by the minister, and that becomes then a legal document. And it can refer to a standard and say that if you use the standard, that you will be then deemed to satisfy the regulation. Just a little bit of that before we actually deal with the competent persons. And the first question here is, what is a competent person? Regulation AZ2 of the National Building Regulations define a competent person as a person who is qualified by virtue of his education, his training, his experience, his contextual knowledge to decide regarding the performance of a building or part thereof in relation to a functional regulation, or to undertake such duties as may be assigned to him in terms of the National Building Regulations. Now, I just want to stop there and elaborate a little bit of that. We get competent persons who've got a qualification that is registered. I think it's the NQ or something that they call it, but it's in terms of SAQA, where a qualification is then registered. So you can go do an accredited course, let's say to do smoke alarm, to design the installation of smoke alarm systems in a building, and then go and install it and to maintain it. So you've got that qualification. So you are deemed then to be competent to do so. The same with a plumber. A plumber gets trained, he gets his papers to tell him that he's competent. And that means that he is a competent person where it comes to the execution of plumbing and drainage work. So also the electrician, etc. In certain cases, by law, there's a requirement that those persons needs then to be registered. And that is where we as architectural professionals, for instance, come in, and engineering professionals, etc., to perform a certain task. Yeah, I know I'm going to be taken on by the plumbing society in saying this, but there's no legislation at the moment that require a plumber to be registered with an organization or a statutory body. In any case, there's not a statutory body for plumbers at the moment. There is a voluntary registration body at the moment who is approved by SACWA to provide education and training in terms of plumbing, but it is not a statutory body. With other words, there's no act of parliament states that that body must be there. They are working on that, and the DTIC is also, in terms of changing the building regulations, I'm part of a task team there, to look maybe into how we can actually bring it into the building regulations. But there's no statutory body in terms of law for the registration, for instance, of plumbing or anybody that do plumbing work. But the building regulations say that you have to be a trained plumber. With other words, you have to have the competency, you must show papers that you've got some sort of qualification to be executing that type of work. We and engineers, etc., are obviously, we've got qualifications or we've got our registration through the bodies as a through RPL, for instance, and even the categories of registration and the qualifications that needs to be obtained to be registered then as a draftsperson or as a senior technologist or as an architect is registered with SACAP. And if you know the Architectural Profession Act, you will see that SACAP is required to consult regularly then with SACWA about the requirements then for training and competencies that needs to be achieved for people to be registered as a professional in the field of architecture. In some of the current SANS10400 standards, then you will see that there are references made and definitions even provided for competent persons or specific competent persons, like for instance, competent person civil engineering, competent person fire engineering, competent person structures. That is against the norm of standards writing, because standards writing can define who is competent or not. That duty is, or duties are given then to the statutory bodies like SACAP and EXA through their identification of work policies then to determine who can do what. And as I speak now here with you, all those references then to these so-called specific competent persons are removed from the 10400 standards, either via amendments. You will note that the recently published 5th edition of SANS 10400 Part T do not at all refer anymore to a competent person fire engineering. It just have the generic definition. The first one there that you see on the screen there, that is in the regulation AZ2 of the building regulations then, to say who is then competent. And the reason for that, as I've already said, is that the standard is a voluntary document and cannot be seen as a prescriptive document or even as a regulation. It becomes a requirement to comply with due to our choice in, or the option that we take on how to satisfy regulations, or if we specify in our specifications that a certain product or service have to comply with a standard, the performance of whoever needs to comply with that specification then makes the use of the standard compulsory, but the standard still remains a voluntary document. Now, the building regulations itself, with others, that is what's published by the minister then. The last great amendment of that, actually it was a revision, it was not an amendment, took place in 2008, and then in 2011 there was an amendment to add XX and XA then to it as well. And Regulation A19 there say that a competent person who is registered in an appropriate category of registration in terms of the Architectural Profession Act of 2000, the Engineering Profession Act of 2000, and the National Scientific Professions Act of 2003, or any other relevant act where the performance of the duty then will be a design duty specifically required by law, and where that person will then be basically seen as the only person with that type of qualification and registration to perform a certain duty, can then, in accordance with the requirements of Regulation A19, prepare and submit to the local authority a rational design or a rational assessment where compliance with the requirements of the National Building Regulations is to be satisfied by reliably demonstrating or predicting with certainty to the satisfaction of the local authority and now I've got a fever as well, so pardon me, today's not my day. Let me just take you back to that. So a person needs to be registered then in with one of those 3 statutory bodies as required by law. So those bodies are there because the law states that they must be there, those different acts. And they are then allowed to, in terms of Regulation A19, to do a rational design or a rational assessment where compliance with the requirements of the National Building Regulations is to be satisfied by reliably demonstrating or predicting then with certainty to the satisfaction of the local authority that an adopted solution, with other words, a solution that is not a deemed to satisfy solution in terms of one of the 10400 standards, but still comply then with the performance requirements as indicated in those standards, has got an equivalent or a superior performance then to a solution that is now the performance requirements that will comply with the requirements then of the relevant part of SANS 10400. So it's clear here that when it comes to design, the designer, which will be then either the architectural professional or the engineering professional, if they then wants to deviate from the deemed to satisfy requirements in a standard, which will automatically deem them to be satisfying the regulation, can then do a rational design or a rational assessment to prove to the local authority that their solution is equal or better than what is in 10400. And allow me just something to say here. There are certain prescriptions on how these things needs to be done and what needs to be done. It is not just the completion of a Form 2 that makes you a competent person. It is not the submission then of some drawings, etc. If you go to the National Building Regulations, especially the A part, like we did last week, you will see that the local authorities can even require calculations. And in certain cases, reports are required to show to the local authority, how did you come to this conclusion that this is now better than what the deemed to satisfy solution is? For instance, in Part T, the new Part T, which we will deal with in the last session, quickly, if you go and look at that, you will see that there's an annexure detailing actually how a rational design or a rational assessment in terms of fire needs then to be done. So it's not just because somebody say a person with a certain qualification must sign a Form 2 that it becomes a rational design. No, a rational design is a specific act that needs to be performed to prove to a local authority that what you've done is equal or better than what is required in terms of the deemed to satisfy requirements. With other words, those rules that you can follow in a 10400 standard that will automatically assure you that you are compliant with the building regulations. Now, such an approved competent person, approved then means, in this case, I believe, approved through their qualification, etc., by the statutory bodies. With others, you've got a professional registration. And my personal belief is that we should actually change this approved competent person to a registered professional in the future, who satisfies then the requirements of the national building regulations in this way in respect of a system, a measure, a facility, a parameter, or installation, is required by law to inspect and to certify upon completion in accordance with the requirements of Regulation A19, then the construction, the erection, or the installation thereof. So, and what is the reason for this? Why can't the building control officer not go and inspect it like they have to do when you do a deemed to satisfy? Because a deemed to satisfy rule in a standard is quite clear. You've done this, check it out, it's there. You've done it according to the rule in 10400. So as a building inspector, I am happy and I can sign it off. But where it comes to a rational design, you know, two engineers can design a slab spanning 5 meters. Although they both will comply with the code of practice for and the standards then for concrete structural concrete design, the way they achieve that outcome might differ. One might use, let's for instance, a Y10 bar and a few more, and the other one might use a Y16 bar, but eventually they will still use, if you understand a little bit of structural design, the same square millimeter per meter square area of the concrete slab or the beam then to satisfy the requirements of, let's say, SANS10100 or SANS29 or 10296, I think is the other one, and a few other standards that they then use then to show that they comply then and have taken all the loads and stuff into consideration. So with a rational design, you can get multiple ways of satisfying it, but it will give you the same performance in the end. Let's go then specifically to Regulation A19. When we speak about competent persons, and A19 then is the regulation that deals then with the appointment of persons responsible for the design, the inspection, and the assessment duties. So where in terms of the NBR and in the respect of the erection of any building, a rational design or a rational assessment is required. Now, the regulation prescribed a few ways where it is compulsory then to do a rational design. The first one is in the regulation AZ41B2. That is, if you can't satisfy a solution by following the rules in a 10400 standard, as depicted then in the regulation AZ41B1, the requirements of the national building regulations can be satisfied by reliably demonstrating or predicting with certainty to the satisfaction of the appropriate local authority that an adopted solution, as I've said, that has got an equivalent or a superior performance. Now, that performance is also in the standard. I'm going to give you an example of what is a performance requirement. We all know Regulation X, SANS 10400XA. Let's say in terms of table, is it now? I can't remember the table now. I think it's, yeah, table 6. If you've got a wall that has got a density greater than 270 kilograms per square meter, and for the energy zone that you are in, it say that you have to use that a cavity wall, masonry cavity wall will satisfy that requirement. So you can use a cavity wall then, and you are not required to show how that cavity wall will then comply with the requirements to make it compliant, because the standard already say by using the cavity wall, you are already satisfying the deemed to satisfy requirements and you are deemed to satisfy the regulation. But say, for instance, you use now something else which has got a density greater than 270 kilograms per square meter, and there's no example provided for, or no rule provided that if you can use that and it will be satisfying that. Let's say, for instance, you go and you're on a farm, you collect a few natural stones and you do a sandstone wall. Then you have to prove to the local authority that the R value of that wall will then satisfy then, depending on the energy zone that you are in. Remember, the density is greater than 270 kilograms per square meter, then that it has got either an R value of 0.45 or an R value of 0.6. That is where you then have to prove, and that becomes then a rational design. But if you use a normal masonry cavity wall, you are deemed to satisfy the regulation, and that is not a rational design. You automatically then satisfy the requirements. So if you have to prove then, with the example given, let's say then a sandstone masonry wall, that you comply then with the requirements of 10400, that is then a rational design where you will then use regulation AZ41B2 then to satisfy the regulation. And there are quite a few other examples where you can do the same. Then specifically regulation A1 subregulation 3 is mentioned as well in this subregulation. And that said that no person shall direct any building which is to be structurally supported by an existing building or extend an existing building unless an approved competent person, with others, that person had to submit then a form 2, which will come later then, has judged that the existing building is capable of carrying any additional loads arising from such erection or extension, and has in writing so informed the local authority. So it's not just the completion of the form, but the local authority here will look for an assessment report of the existing building and then the design of the new part of the building to show that it is still, that the whole structural system of the building then will be sound and compliant in with legislation. Another specific regulation that I mentioned here is regulation 823 sub-regulation 4. And this say that the local authority may, at the request of the owner, grant approval for one or more extensions of the period contemplated in sub-regulation 3 then for temporary building. So the owner have applied for a temporary building, have given a time period there, got the authority from the local authority or the approval from the local authority to erect this temporary building, but now they want to extend the period, and in that case, if the public should have access to such building, they will then be requested that such a request for the extension of the time will be accompanied by a certificate signed then by an approved competent person. With other words, in this case, a person that is registered with EXA and is trained in structural stability and stuff like that, indicating that the condition of the structural system is satisfactory. Then another one that is specifically mentioned here is regulation G1 sub-regulation 3. And what does that regulation say? Where the safety or the stability of any property or service is likely to be impaired by an excavation, or where the depth at any point of an excavation is likely to be more than 3 meters, the owner of the site shall obtain the prior written authorization of the local authority for such an excavation, and they have to take the precautionary measures specified by the local authority or an approved competent person into consideration when they're exercising such the things in terms of such an authorization. Another regulation that mentioned that is specifically requiring a competent person to do work will be regulation 04. And let's say that any rational design of an artificial ventilation system shall be carried out by or under the supervision of an approved competent person who shall certify in accordance with the requirements of regulation A19 that the system has been designed to comply with regulation 01. So regulation 01 will give you then deemed to satisfy requirements for ventilation or performance requirements, in this case for ventilation, that is currently air changes per hour. The new part O will deal with something else. I think it will go to CO2 levels. But that is why the moment you do an artificial ventilation system, and I'm not talking here about room air conditioners, I'm talking here about systems that blows in fresh air into a room and extract then the the air out of the building so that there's circulation to accomplished in the building so that there's always a supply of fresh air. That is where you do not naturally ventilate it by opening then a window. So that's one of the other regulations that in terms of regulation A19 then requires a competent person to be involved. And it doesn't stop there. If we go to regulation B2, sub-regulation 2, it says that the requirements of the design of a drainage system shall be deemed to be satisfied where you satisfy SANS 10400 Part P, provided that if the local authority is of the opinion, and I just want to stand still here quickly, what is an opinion? An opinion is an opinion in writing, providing reasons for such an opinion. Not just because I say that you will do it like that. There must be a reason provided per request in writing from a local authority if an opinion is required, and that opinion must then be explained in such written documentation. That the size of or the complexity of the drainage installation in a building renders it essential for such installation then to be the subject of an approved rational design prepared by an approved competent person. And as you can see there, it says that the local authority shall in writing notify the owner of such building of its reasons then for the necessity for such a design, and it may require such an owner to submit for approval plans and particulars of a complete drainage installation based on such a design. So it's not just somebody there that can make a note and say, oh, we need a rational design. Details must be provided not to the professional, but to the owner of the building. And the owner of the building will then deal with the professional and give him all the reasons. Because remember, although we act as the agent of the owner is still the responsible party. So the owner needs to make the decision, in this case, do I go ahead with the project or not? Do I appoint in a competent person or do I not appoint a competent person? I don't believe that we've got the right because of the financial implications here and that we might go out of budget, and we actually are going to extend the scope of the project if we then on our own as a professional being notified by the local authority of this requirement, appoint then a competent person to do the work. First of all, as I've said here, the local authority has got a legal obligation. It's an administrative action that they have to take to notify you and to give you reasons for that. And failing to do so, it becomes unjust administrative action, as explained last week. And I think that is section 36 of the Constitution, also one of the constitutional sections then that come into play that say that they must give you reasons in writing if any legislation requires that or if you ask for that. The same is true for regulation Q3 as well. And the regulation Q3 say that the requirements of the construction, the siting and access of non-waterborne means of sanitary disposal shall be deemed to be satisfied where the design and construction, siting and access to such other means of sewage disposal satisfies then the requirements provided in 10400 Part Q. Again, here is the provision that the local authority, if they are of the opinion that the nature and the means of the sanitary disposal is such that it is essential for such installation to be the subject of an approved rational design prepared by an approved competent person, the authority then shall in writing notify the owner again of such building of the reasons for the necessity of such a design. It might be dolomite land. It might be clayey areas where percolation is not going to happen, for instance. Then they must provide those reasons to the owner, and in such a case then they may require then the owner to submit for approval plans and particulars of a complete installation then based on such a design. So again, we see here, and it's going to come up one or two times in the next two slides as well. In the opinion of the local authority means it is a document that needs to be submitted to the owner providing reasons, spelling out the reasons why it needs to be done. Not because we want it just like that, or we will not approve it if it's not done like that. Reasons must be provided. Otherwise, it is unjust administrative action. And I want to put emphasis on this because I think as architectural professionals, unfortunately, we have allowed over the past 20, 30 years a lot of unjust administrative action to happen so that everybody at the moment think it is the norm. But the Public Administration to Justice Act have got provisions in there on how then to deal if you feel that you are unfairly, that the administrative action that you are subjected to is then unjust or unfairly. And we as professionals and owners should actually use that. Allow me to say that I've also heard that a lot of professionals said, yeah, but then we're going to get victimized and we're not going to get our plans approved. That is also unjust administrative action. And the Budget Act do actually state it's not going to be an act against the local authority. It's going to be an action taken against the entity, the official that is responsible for that unjust administrative action. So he or she might actually lose their job and be fined or even going to jail if they continue to do so. And we as professionals must just make sure that we insist that those things are happening. Because the way it is going on at the moment, unfortunately, causes the construction of buildings to be delayed. That's got financial implications, and we are hurting the economy like never before due to certain of these actions. But it also means that, you know, for every responsibility, there's something else as well that I also, as a professional, must make sure that I have satisfied my responsibility and the actions that I have to do in such a case. Then we come to Regulation 1, R1, Sub-Regulation 3. And it say here that the requirements for stormwater disposal requirements shall be deemed to be satisfied with such means of stormwater disposal is provided in accordance with SANS10400 Part R. Provided that where the local authority is of the opinion that the conditions on any site render it essential that for stormwater disposal to be the subject of an acceptable rational design prepared by an approved competent person, the local authority shall in writing notify the owner of such sites for its reasons for the necessity of such a design, and it may require that such owner then submit for approval plans and particulars of a complete stormwater control and disposal installation for such site and for any building erected thereon based on such a design. Now, I will come back to this specific regulation and then the SANS10400 Part R in the 4th series as well. But I just want to say to you now, what does the regulation say? The regulations say that the local authority cannot prescribe certain ways of doing stormwater disposal. They can actually only inform the owner, providing reasons why it's necessary to do a rational design, and then a rational design needs to be submitted to address the problem. So a local authority, if they've got, and that's my take on that, and I think I'm correct in that, if I read the rest of the A regulations, cannot go and prescribe that you have to have continuation ponds or certain things in place through a bylaw or through a policy, etc., because that is repugnant then to this regulation, which say the owner has got the opportunity to do a rational design, because there might be a much more economical solution to that. And in fact, if you know your regulations and you go to Regulation R2, Sub-Regulation 2, you will see that these things are not required for H4 occupancy or sites where a building is going to be strictly used for residential purposes. And if a local authority require for a specific site then additional requirements, they are also under the obligation then to provide you, the owner then, with reasons in writing and the request then a rational design then to be done. Not a specific performance or a specific thing to be done on the site, but a rational design where the owner then, through a competent person, then do what is best for the site as long as they satisfy the performance requirements that is needed to satisfy or to provide a solution then for that problem. And again, here, I think we got so used to be prescribed by other or by local authorities on how to do certain things that we forgot that there is legislation in place that is actually requesting, or not requesting, requiring the local authority to act in a certain way. And if they do it in another way, the building regulations quite clearly states that it is not accepted. Another one, and yeah, we can talk about that also the whole day when it comes to competent persons, is then the regulation T1 sub-regulation 2. This regulation say that the requirements for the design, the construction, and the equipment of a building regarding fire protection shall be deemed to be satisfied where the design, the construction, and the equipment of any building complies with 10.400 Part T. So if I in my design as an architectural professional comply with all aspects of Part T, in most cases those are architectural interventions, fire separating walls, that is an architectural thing. You design your wall to be a certain thickness and to do certain things. You put fire extinguishers in certain places. You put fire hydrants in certain places according to the rules provided to you in Part T. Then you are deemed to satisfy the regulation. And nobody can come and say to you, oh, we need a rational design and we will not approve the plan before you provide us with that. In any case, a fire chief or a fire inspector cannot approve or refuse a building plan. The building control officer, in terms of legislation, that is now Section 9 of the Act, needs to take the report from the fire chief into consideration in his report to the council or to the decision maker for the refusal or the approval of the building plan. Meaning then that if a request from a fire department or a fire chief is not in line with the requirements of Part T of the National Building Regulations, listen carefully now, the building control officer in his report to council can override the recommendation by the fire chief. And then the decision maker have to apply his mind to that recommendation, and he can even override then the building control officer's recommendation, because he needs to apply his mind and make sure that he satisfies this Section 9 of the Constitution. Not the Constitution, the National Building Regulations and Standards Act. And this was tested not once, but a few times in the Constitutional Court. And I invite you to go and search for Constitutional Court cases regarding the National Building Regulations. And you will see time and again, local authorities get hidings in the Constitutional Court for not complying with Section 9. And still, we as professionals, allow them to carry on with this, and then it's creating these problems between us and local authorities. We need to know what are the powers of the certain entities at the local authority, and the building regulations only and the Act itself only talk about the building control officer and his recommendation. How he obtains recommendations from the different parties is his or her doing. It's got nothing to do with us as the professional. It's got nothing to do with the owner on how the building control officer exercise his powers then in obtaining further information to make such a recommendation. The Act only say the building control officer must make a recommendation. The Act doesn't say and that the fire chief must give a report to the building control officer. That's the only things that is there in law. There's no requirement in law that the plan must go to traffic, that the plan must go to this. Those are actually land use management issues that needs to be sorted out before you actually submit a plan to to building control, and which needs to be addressed in a site development plan to ensure that traffic issues and other land management uses will not delay the approval of a building plan. Okay. So again, if the local authority is then of the opinion that Part T or the application of the SANS10400 Part T will not satisfy in all aspects a certain aspect, they must provide such an opinion again then in writing to the owner, give reasons for their opinion, and request then the owner to do a rational design. Now, thinking about that a long time, sorry that I stand a little bit still on this issue now here. Just allow me just to drink a drop of water quickly. Pardon for that. So, when will a local authority have a reason to say that the Part 10400 Part T will not satisfy, in their opinion, all aspects, where it comes to the protection of the occupants in a building and all those things that is required in terms of Regulation T, Sub-Regulation 1? You know, a few years ago, before COVID, I was flying into George. At that stage, there were huge veld fires going on there, and I just realized, look, if you look at Joburg, we've got lawns, we've got paving next to our houses. We haven't got the type of vegetation that they've got down there in the Southern and the Western Cape. You know, fynbos doesn't grow up to a house, and fynbos has actually got a high fire load to it. So yes, in such a case, the local authority may require additional requirements because of the way things are done there. But if you're in a normal residential area or in an industrial area here, and there's nothing untowards, and everything complies with building lines, etc., and fire safety zones, there will be no additional requirements according to me. Except if you use, or if you're in an estate, for instance, and the estate require, let's say, that all walls may be of timber, or all roofs might be of have to be out of thatch. That is then creating an additional fire hazard, and in such cases, local authorities may require rational designs then to mitigate the additional risks that certain requirements by homeowner associations, etc., then put on the fire safety of the building. Okay, let me step off fire. We're going to do fire in detail a little bit later. Next, the Regulation A19 also specifically mentioned the Regulation W4, and that is the requirements of the design of fire installations shall be deemed to satisfy if we comply with Part W. I will talk about that in detail a little bit later in the fourth session as well. I'm not going to go in there, but all that I want to say to people is, remember, you can't just indicate a fire hose reel and a fire hydrant. You need to comply with Part W, and you must make sure that the simultaneous use of all those fixtures in a fire division must be able to come into operation simultaneously. So there's a small calculation that you have to do to determine pipe sizes, etc., and that must be then on the building plan. So if you do not satisfy those requirements of Part W, then maybe you have got more fire hydrants in a division that's required, or you've got a sprinkler system installed, then the regulation quite clearly say that you will have to get a competent person to do the design, or the local authority again can provide you with their opinion and their reasons why they think that just a normal compliance with Part W will not be okay. And then we come to our dear old Regulation XA. And in this case, it's specifically Regulation XA3B. The deemed to satisfy requirements like I've mentioned earlier, the wall, a cavity wall versus a sandstone wall. That will be covered via the requirements that we've, if you want to look at R values, etc. That is regulation AZ41B2 that we have to, and that is through that then that we satisfy regulation XA. But the B part of regulation XA3 say, where the building is the subject of a rational design by a competent person, and it demonstrates here that the energy usage of the building is equivalent to or better than which would have been achieved by compliance with the requirements in SANS10400A. Now, what has been referred here to will be the energy use, that is energy use as well as energy demand in terms of the tables, and you use software then to do simulations, and you prove then that you have to prove then that the building has got a demand or a consumption less than what is required in terms of the tables, etc., that are provided in regulation or in 10400XA. That is a rational design. But if I do it in terms of the A part, where I prove compliance with fenestration, etc., and I do a little bit of calculations to, well, fenestration is now excluded because 204 has been withdrawn. So table 4 takes the place on that, and that gives a deemed to satisfy for every scenario, basically. So there are a few others like walls, maybe, that you can do that. In that case, it is the AZ41B2 part that comes in. So there is no requirement that if you do anything in terms of energy use in a building, that you have to submit a Form 2. Only if you do in terms of AZ41B2, as I've explained, a rational design, or if you do energy modeling, where you have to provide a theoretical, you do a theoretical assumption that the building will satisfy the requirements of XA, that a Form 2 or a rational design is then actually needed. If you just normally satisfy it, no requirement of a rational design needed, and you do it normally as you do any other deemed to satisfy rule. And on the subject here, there is no competency certificate or any other certificate or any CPD certificate required by law to be submitted to a local authority to show, especially if you do the deemed to satisfy requirements, that you have done a course on XA, etc. It was just a suggestion made by the NRCS right in the beginning to assist building control officers so that they know that those people who are submitting building plans were exposed to the legislation. But it's now 13 years later, and we all were exposed to the legislation, and there is no requirement in the building regulations or even in the Act that we need to submit specific or special forms or certificates to a local authority. The fact that you are registered with SACAP make you, and in terms of, and if you act in terms of your IDFW work practice matrix, you are indeed entitled to do that work without any further education, etc., or any certificate required. So just that thing as well. And I think, well, I know that I still get a lot of queries even by local authorities regarding that, and that is the answer to that. There is nothing. If you can show me something, I will be glad to accept it then, but there's nothing to say that you need now a specific CPD certificate to show that you were exposed to the legislation. Otherwise, there would have been one for Part K, for Part L, and Part M, and all the other parts as well. But the fact that we are registered as architectural professionals makes us competent to do that work and to do the deemed to satisfy work for that. It's part of our standard service that we are engaging in with our client. Okay. Now, with all of this, AZ41B2 and all these others that we have done, in respect of a system, a measure, a facility, a parameter, or installation, or any part of 10-400, as I've explained with the XA issue, or where a geotechnical investigation is required in terms of Regulation F3, geotechnical site and environmental conditions, the owner of the building has got a legal obligation. He shall, subject to the provisions of sub-regulation 4 and 5, appoint and retain one or more approved competent persons to undertake responsibility for the work associated with such regulations, including any inspections and certifications that may be required. Allow me now, and there's enough time today to do so, to explain a little bit further on this. You may be appointed in terms of your architectural professional agreement up to stage 4.1. With other words, your responsibility to your client and the services that you render to the client is then get the building plans approved by the local authority. But you're not going to be involved in tender documentation, in site inspections, and in close out of the project. He doesn't need you for that. So he only engage your services up to stage 4.1 to get the things through the local authority. But even if you do not do a rational design, you are, by the requirements of the National Building Regulations and Standards Act, and you actually declare that in Form 1, as you will see a little bit later, that you will be available at all times until a certificate of occupancy is issued for that building to act on a few things that may be required after that. And that is why we need then in our fee proposal need then to also to spell that out. What happens after plan submission if I'm only do up to plan submission? What if my services are required after plan submission in terms of legislation? How am I going to be remunerated for that? So that is just a little bit about office practice that comes in there as well. Let's look at sub-regulation 4 of regulation 19. The owner of a building who is required by these regulations to appoint an approved competent person shall state in terms of the appointment for the competent person that such person undertake all duties and responsibilities required by these regulations. All duties and responsibilities, not just half of it. For instance, and it's now fortunately not in architecture, but in engineering, an engineer who is competent to do structural systems takes responsibility for the structural system of the building. Not just the foundation, not just the walls, not just the roof, because all of that is part of the structural system of the building. So they can't decide, I'm going to exclude this and I'm only going to do this. They are bound by law to undertake all the duties and responsibilities as required by these regulations and to deal with that then. And they have to declare then their acceptance of those responsibilities, not the fact that they are appointed by the client to do the rational design. They declare their acceptance of those responsibilities in that portion of Form 2 then that they sign. More about that later. Sub-regulation 5 of Regulation A19. A person may be appointed to undertake the relevant responsibilities and duties in the respect of more than one of the systems, measures, facilities, parameters, or installations provided for if the local authority accepts in terms of these regulations that he or she is competent to do so. So you might get a civil engineer and he do the civil engineering work, but he might also be capable of doing the structural work. So you might be able to accept the responsibility for both the civil engineering as well as the structural engineering work. As an architectural professional, we might accept then responsibility for the design of the roof, excluding then the structural part of that. I'm talking here about the design of the roof, the selection of materials, what waterproofing, etc. If it does not satisfy those requirements in terms of Part L, we might also accept a responsibility for XA, for instance. We might accept a responsibility for facilities for people with disabilities if we do not comply with the deemed to satisfy requirements of Part S and do a rational design then. So as you can see then, it is not just that one person needs to be appointed for one specific. You can actually do then more than one, and that needs then to be indicated as such on Form 2. So you tick then more than one box on Form 2 for that matter. What happens now if it's not possible for you to fulfill that function then, if you have signed Form 2, where it comes to a rational design as a competent person, then you have to notify obviously the local authority as well as the owner, and the owner then by law have to appoint another competent person with the same qualifications, etc., to take over those duties, not just those that are not completed as yet, but also those that were completed up to date as part of the design. So you take responsibility for everything then when you take over the work of another competent person where a rational design or a rational assessment were done. There are cases that the local authority may exempt the owner then from the requirements of this regulation for a building that is classified as minor building work. Okay, so remember that minor building work is defined and building types are mentioned, and it also says that these have to comply then with the national building regulations. So let's say you do a steel carport, you are required then to appoint the owner to appoint a competent person in structures to do the design of that, but you can apply to the local authority to be exempted from that, not automatically, but exempted from that, because although that carport satisfies the definition of minor work, it does not satisfy the requirements of the specific standard, and therefore it needs a rational design. So furthermore there, you have to apply then to be exempted, or the owner needs to apply to be exempted then from the requirements to appoint then a competent person to take responsibility for that design. But in many cases, just by the way, if it's just a carport that is erected, that will be okay. But if it's a whole new building, 10-to-1 for the foundations or for any slab design, etc., a competent person will automatically already have been appointed to take responsibility for the structural system, and therefore he or she will then, by the fact that they have to take responsibility for the complete structural system, also take responsibility for that design then. When it comes to foundations, if there's an existing buildings, and you can see here that where the applicant has satisfied himself that the existing foundations are in accordance with the rules contained in 10400 Part H, they then also do not have to appoint a competent person to do the design, etc. But remember that that is an extension of an existing building, and a structural assessment of the building needs to be done as per the previous regulation that I've mentioned here, where a competent person is required. And the only way that a client or an applicant can satisfy him or herself that it does not need to comply then with the latest requirement, let's say of Part H, is when a structural engineer in its assessment report indicates that the existing design of the foundation is okay and that you can carry on doing such a design. It is not, an architectural professional, by the way, cannot do this because it is not earmarked in the scope of work for architectural professionals by the CBE. It is for engineering professionals, because our PI will not cover us if we take responsibility for any structural issue. Where the building is then also to be extended, the local authority may, on the receipt of the application for such extension and before granting approval, require that the approved competent person who have accepted responsibility for such work to timelessly prepare and submit rational assessments as to the adequacy of the existing systems and installation. So it's not just, oh, my assessment report will be okay. If the local authority comes to say, well, we've picked up something in your assessment report and therefore we are of the opinion, and we gave you the reasons for that, we then require you to submit full detailed rational design drawings, etc., for the extensions, etc., but also for the existing building to show that it complies. If the local authority is satisfied that such rational assessment meets the requirements then of the NBRs, it shall accept such assessment, which shall be deemed then to be part of the application submitted. However, they can also be decide not to be satisfied, and they have then to consult with the competent person and request him to submit another assessment after they have furnished their reasons why they cannot accept such an assessment, and then they will have to allow that competent person to submit then, as I've said, then a revised assessment that will satisfy then the local authority. Now, where in a building any element of the structural, the fire protection, the artificial ventilation, the stormwater disposal, or the non-waterborne sanitary disposal, fire installation, or drainage installation system is required to be the subject of a rational design or a rational assessment, the person appointed as the approved competent person shall assume responsibility for satisfying the functional regulation relating to that system in its entirety. With other words, a structural engineer cannot say, I'm only going to take responsibility for the new addition to the building. He must do it for the complete building or group of building where the addition has been added to on. The same with fire, the same with ventilation, etc. So they can't just come and say to you, I'm only going to be responsible for the new part. They have to do an assessment of the existing part, and in many times they have to do adjustments to the existing part to bring it up to speed so that the building is still deemed to be a health and safe environment. And now, where the approved competent person is required to assume responsibility for the system in its entirety, and in this case, I can call up the structural system here, and where parts of the system are undertaken by other competent persons. With other words, you might have a specialist timber roof truss engineer that is designing the roof trusses. Okay. The approved competent person, with others, that person that have submitted the Form 2 to the local authority and got approved, got accepted in terms of that, not approved, shall assume overall responsibility of the design of such system. So there's a duty then upon that competent person to ensure that, let's call it system or partial designs of the structural system then done by other competent persons are indeed then in line with all the requirements of the National Building Regulations and fit for the purpose of that structural system of that building. And he can actually request that other competent person then to, if he is not satisfied with the design outcome, to provide him with details, etc., and actually to amend the design, etc. And he then co-signs it when it is required to be submitted then to the local authority. Okay, that's the buttons on that slide. So I'm just going to go away from that slide. Now, any person that's appointed by the owner to do rational designs then, or even assessments, must apply to the local authority for acceptance. Because the local authority have to check if this person satisfies at least 5 requirements. And it's not an application that will have to take forever. When this was discussed here in 2010 around that, when Part A was developed in the first instance after the regulation was publicized, consensus was actually reached at the then Building Control Officers Forum, or that it is only a matter of fact, you submit the form to the local authority, You can even do it before you actually do the design. Whoever receives the form, just check quickly, did you comply with this, and this? And if you've complied with that, you are deemed to satisfy then the regulation. And then they complete the section 4 of that form. They give it back to you so that you've got evidence that you were accepted for PI and other insurance purposes. And then you can carry on and you are accepted then as the competent person. So what are those things that they have to check? First of all, did you complete the form correctly? And did you fill in all aspects that are all fields that are required to be completed? If not, obviously, like anywhere else, the form or the application will be rejected due to incomplete information. If the owner is not an employee of the owner and of the building and is not in possession of professional indemnity insurance cover, a local authority can refuse to accept the person as the competent person. And note here, I say accept, not approve the competency. They accept the competency based on what you submit to them in Form 2. Pardon. So, and there's a lot of queries and misunderstanding of what is if you're not an employee of the owner of the building. Let's say I work for Eskom. I am an architect and I'm employed by Eskom, and part of my duties in terms of my employment agreement with Eskom is to design buildings for Eskom and to submit those plans to the local authority. Then I do not need to have PI insurance. Why? Because I am an employee and the organization will have insurance to cover misconduct by their employees and anything that an employee might do that cause financial losses to them. Furthermore, the Labor Act, etc., will then regulate on how action needs then to be taken against such a person who, in line of his employment, the duties imposed upon by his employment do not then satisfy those. But if I'm a consultant and I contract with a company and I'm on my own a consultant, with other words, I act as an individual and I contract via a client professional agreement with a client to do certain work with for the client, then if it's a rational design, I need to be covered by professional indemnity insurance. In any case, we as architectural professionals need in all cases to be covered by PI insurance. However, a local authority, the only time that a local authority can insist on proving that you've got a PI cover is when you do a rational design. And in such a case, they may not accept you as the competent person if you can't provide that. It is not that they have to not accept you, it's that they may not accept you. It might be a small thing, and the chances that whatever you're going to do is going to create great havoc or danger to the public, where PI cover then will have to come in because you might not be able to financially make it correct afterwards. That's where they then will surely then insist on PI cover. The other thing is that if you do a rational design, they must check that you are professionally registered, either with the Engineering Profession Act, and that the work that you do then falls within the scope of your registration with EXA in terms of their identification of engineering work policy. If you are in architecture, you have to be registered with the Architectural Profession Act, and whatever you do must be in line with your competencies as per the identification of work policy. Or if you do something like geotechnical investigations, etc., that you are indeed registered with the National Scientific Professions Act, and that whatever you do there is then in line with the duties imposed on you by your registration in terms of the National Scientific Professions Act. The fourth one, the local authority can also be of the opinion and this is a difficult one, because remember, an opinion must be an opinion in writing. So they must give you reasons why they think that you are inadequately qualified or has insufficient experience or contextual knowledge to make determinations that are required in terms of these regulations. However, if you are, and that, if your duties are then as per the 10400 standard, and I think here the regulation also needs still to be updated, because it tells the standard to define, and the standard can't define who's competent or not. It must be in the regulation itself, and that's what we are working on as a task team at the moment. With other words, if they must be satisfied that you do not have the competencies as required by the registration authority. That's how actually we have to tell it to satisfy this. However, if you are registered in a category of registration and that deems you to be competent in that field, they cannot actually then say that you are inadequately qualified to do that type of work. And then the last one, if you are under investigation by disciplinary tribunal of the Engineering Council of South Africa, the South African Council for the Architectural Profession, or the South African Council for Natural Scientific Professions. But not just because you're under investigation, because you might be not guilty, because you're still under investigation. Remember, not guilty until proven guilty. But you might have done such a disastrous thing that the registrar or the chief executive officer has expressed an opinion in writing. And my interpretation of that, how is Advocate for Dooley, for instance, going to inform local authorities that Joe Block, as I hope there's not an architect with the name Joe Block, but that Joe Block has done something so disastrous that is under investigation for that, and the likelihood is that his registration is going to be cancelled. How do they express an opinion in writing? I believe that is via a board notice then in the government gazette, because it must be made public so that everybody knows about that, you know, this guy or this lady should not be considered for any rational designs in that specific field. So, where in respect of any building, the local authority, after consideration of the details of registration in respect of category, date, and discipline in which the applicant is registered, qualifications, experience, training, and contextual knowledge provided in terms of this regulation by any person seeking acceptance of his or her appointment as a competent person, and the declaration of competence provided then by such a person, considers then that the person does not possess the degree of competence necessary to undertake the relevant duties, it may then decline to accept the appointment of such a person. So it is not a given that a local authority will have to accept your Form 2. They may decline to accept your Form 2. And if they are satisfied that you are okay, how do you know that the local authority is either not satisfied or satisfied? The regulations say that they must indicate that on Form 2. And Form 2 has got a section 4 to it. Now, how many people submit a Form 2 to a local authority? Everything gets done, but the local authority never ever comply with their statutory requirement of letting you know that you were accepted or not accepted by giving you back Section 4 or Form 2. We are taking risks left, right, and center if we do rational designs, and definitely I think the engineers as well, by not insisting that the local authority provide us with Section 4 or Form 2 back so that we've got it on file, because that is our proof if something goes wrong. To our PI insurance, to our legal team, etc., that we were indeed accepted. Because without that, yes, a local authority might accept my building plans, and then it might be argued, but due to the fact that they've accepted it, it means that, or that they've approved my plans, it means that they've accepted my competency. But there is a legal requirement, like you have to stop at a stop street. The local authority have to give you back Section 4 or Form 2 to enable you to do your administrative stuff and to enable you to protect your risk, to manage your risk with your insurers, etc., if something then actually happens. Now, there is a legal requirement put on people who are doing structural fire protection and fire installation systems, and if they've done a rational design. With other words, they were accepted, first of all, as the approved competent person. They have submitted to the local authority a Form 2 for that purpose. They've got Section 4 back of Form 2. Then on the completion of that system, only then can they actually submit a Form 4 back, to the local authority, stating that they take now responsibility for the execution of the construction and that everything was done according to their detailed design. You cannot submit a Form 4 to a local authority if you were not accepted in terms of a Form 2. And we are aware of the fact that there are local authorities that, regardless of the fact that you've done a rational design, they want a Form 4 for certain things, even if you've done it via a deemed to satisfy solution. Now, not complying with the conditions of the National Building Regulations constitute a criminal offense according to Judge Jafta of the Constitutional Court. So if you submit then a Form 4 and you take responsibility for something which you were not required by the law to take responsibility for, you, with others, you haven't done a rational design for that. You may not even have done inspections for that because you were not required because you were not appointed as the competent person. You are taking a risk as a professional. Doesn't matter if you're architectural or engineering. And it might backfire on you later on because your PI might say, well, you've taken on the risk that we were not prepared to cover because you did not follow the steps to actually for us to see that you can take that risk. So you've taken the risk outside the scope of your appointment, outside the scope of your insurance, etc., and that can bring big trouble for you. You can also be in very extreme cases, be found guilty for not complying with the National Building Regulations because you have completed a form and provided information on a form which you were not entitled in the first instance to supply to. So we need also to communicate that to local authorities that a Form 2 can only be requested from a professional if that professional was responsible for the rational design and were accepted by the local authority via the completion of Section 4 or Form 2. Otherwise, you are not entitled to request from me a Form 4. And I cannot actually submit a Form 4 to you even if I've done a rational design and even if I've submitted a Form 2 to you, because you did not, I have got no proof through Section 4 Form 2 that you've actually accepted me. And I'll show you that just after the break later on. What about Regulation XA? Where Regulation XA is satisfied via rational design, that is now the XA3 part of that, or via Regulation IZ41B2, the competent person who is responsible for such determination shall, on completion of the construction and commissioning of the building, submit then a Form 4 to the local authority. Not just because you have done XA, you have to submit a Form 2 and have accepted the responsibility for a rational design, either through the fact that you have done something else than the deemed to satisfy when it comes to the building envelope in terms of Regulation IZ41B2, or where you have done a simulation in terms of XA3B and was appointed then as the competent person there. So again, there you need to be accepted first in terms of Form 2 by having Section 4 of Form 2 completed and handed back to you before you can be requested to submit a Form 4 to the local authority. And I've actually added the last sentence in there, where any person provides any information or certificate required in terms of this regulation in which he or she knows to be incomplete or false. So if you submit a Form 4 to a local authority and you were not accepted, you actually providing a false declaration then to the local authority, because you are not entitled in the first instance to do so. You are guilty then of an offense. Okay. Just before I end, where does the competence come from? And I've said that it is the statutory body SACAP and EXA that determine who's competent to do the work. And I'm just going to flag quickly the 10 competencies of SACAP on the screen there for you. And then you can go and Google it on the SACAP website. You will see then there how those competencies needs then to be addressed by the different professional registration categories and what are expected then from them in terms of that. Just Google SACAP competencies and you will get this document quite easy. You don't even have to go onto the SACAP website to go and get it. You just quickly Google it. Then with EXA competencies, you just Google EXA, IDFW, they call it IDOEW, Identification of Engineering Works. And there you see they've got quite a number of tables for professional engineer, engineering technologist, and certificated engineer, engineering technician, and specified category practitioner, and the competencies which they are then deemed to have then to do certain type of work. So all of these things are out there in the public domain for us to go and check. Okay, it's now 11:48 and I'm not sure how to deal with that, but we can take now till, let's say, 12 o'clock, a few questions. I'll just see if I can see the questions here, or if you can help me.
Yes, yeah, we can take questions from colleagues there. They can right now I see there are 2 hands, but I can also read the one on the chat. Let me start with the ones there. I see 3 hands. Let me start with Potrika, then followed by Paul, then followed by Mr. Danashwa, then followed by Anton. I'll stop there. Let's get this. You can come in. Paul, you can come in. Anton, you can come in. Mr. Banashwa. Angela, kindly unmute your colleagues. Yes, Angela, you can go ahead to ask your question.
Good day, everyone. I just want an emphasis on the register, where we should register and indicate that we have attended the training. Is it the form where I filled in my reference and my initial and surname?
Okay. Thank you very much, Angela. So what this is, the moment you logged in and you register, you then you attend. The time that you attend, it will then reflected on the spreadsheet that we are going to take from the system. And you have also answered the question that we have put in. We will check the system here. It will tell us how much time did you attend. If it is a 4-hour event, CPD points will only be allocated to people who attended more than 3 hours. Yes, we will see there are others because of load shedding and so forth, where there is in and out, we will determine those ones. If you are on the system flag out that you only attend for 45 minutes, definitely there will not be points that will be allocated. You all need to answer all those questions that we are going to flight here. Remember, the board notice of CPD states that it must be interactive and you must attend 4 hours to get CPD points. And also, we had also received quite a few emails, people asking for SACCUP certificates. We don't issue certificate. We only allocate CPD points on your profile. Thank you, Angela. Let me take another question. Mr. Banashwa or Paul?
Apologies, I accidentally raised my hand. All in order for
Okay.
myself.
Okay, thank you very much. Anton? Paul and Fikile. Okay, all right. It seems all the people who are raising hands, they don't want to speak. You just need to unmute the Pinani Wood. Please, you can yes, go ahead.
Penina
sorry.
Wood.
Yes,
Good
my
morning.
apology. Good morning. You can go ahead.
It's all good. It's not an easy name to get right, but once you get it right, it's easy. Good morning, and thank you so much to all, and especially to our speaker, Mr. Decker. Mr. Decker, can you hear me at all?
100%, Nina.
Thank you so much. Thank you very much. I'd like to ask a question about the power of attorney form, if I may. You very eloquently explained to all of us about the restrictions about this, and this has been extremely helpful and highly informative. Thank you so very much. I'd like to ask about the POPI form. Does that have to be, is it a compulsory or I'm sorry, please forgive me. I'm not quite sure if the word compulsory is the right terminology in this case, but when we fill out and sign and submit a power of attorney form for an application to be approved or a case with the local authority in particular, is it of good practice to submit a POPI form that is generated by the local authority? I have come across that form before. Please forgive me, I don't know the code of the actual form, which is normally illustrated and indicated on the form in the top right corner of every form. There's a little number, LUM-16, etc., for example. I'm not saying that is the right code or number for the POPI form. I don't know the exact number for this form, but I have come across the POPI form, and would that be suitable? And is it a requirement or compulsory to submit this form when you fill out a power of attorney?
Okay,
Sorry,
I hope I understand your question correctly. Let's look at the first instance. Is a POPI form, I haven't seen one as yet, but I can imagine what it's all about. Is the completion of such a form and the submission to that then satisfactory to deal as a power of attorney? I don't think so, because what I've read and my research about what is a power of attorney, it's a specific documentation, a specific declaration made by the owner to allow you certain rights to act on his or her behalf. POPI is about the protection of personal information. We all have to comply with POPI, So we cannot disclose any information in our possession of our client or any other possession information that are privileged that we might come upon to anybody else. Our systems must be so that it cannot be hacked. So you have to make sure that you've got enough security software, etc., so that nobody else can actually, by accident, see what you are doing and get information from your screen while they walk through your office that are confidential, etc. So I think those are two things. Yes, I'm not sure why local authorities ask you to fill in a POPI form. I know that. Okay, the POPI form is that they have got then the right, or that gives them the right to obtain certain information about you, let's say from SACAP or from the owner from, let's say the deeds office or even SARS and stuff like that. That is what a POPI form then will basically give you. That gives the other entity the permission to obtain that information, which is normally then privileged information. Power of attorney is something different. That is where the owner gives you information to act basically as his agent and to request certain information on his behalf, and they give you the information for that.
Sorry, Mr. Decker, I received a POPI. I'm hearing what you say, and I thank you very much for your response. As you're speaking, I think I realized that this POPI form, which was requested by the case officer at the time for a particular application, requested that surrounding neighbors, had to be approached. And I think that's where the POPI declaration came in for the case officer. Yes. Requested the applicant, the agent, to acquire various information from surrounding neighbors.
That's correct.
So I'm thinking that is where, but what struck me when you were speaking is that when you were talking about the power of attorney, you mentioned about just being, vigilant around the confidential information, which is, as applicants, we deal with highly confidential information. I was just asking the question because I've only received the POPI form with a particular case and not any others. And while you were speaking, it crossed my mind whether this would be now, with all of us needing to be more vigilant and sensitive and aware of our role as professional applicants on behalf of the owner. I was thinking, would this be an act of ethical conduct, in brackets compulsory, or for us to fill in this POPI act, a POPI form, and attach it to the power of attorney, so to speak. But thank you. I'm not going to take up any more time. I think we've discussed this in full. Thank you so much.
I can just add to that. If you look
Yes.
at our code of conduct, there is an obligation on us as part of our code of conduct to treat all information that we receive confidential, and that we cannot disclose it without the approval of the owner of the site or a client to any other party. So if we are required outside the scope of the law to disclose that information to anybody else, then we will need to have the owner's permission to disclose that. And I think that is what the so-called POPI form is then all about. Thank you.
Thank you very much. Thank you.
Thank you. Then Jackie, you can come in.
Hi, good morning, Mr. Decker.
Morning.
Hi. Sorry, mate. Is it possible I can ask you a couple? Sorry, I didn't get to ask questions last week. Is it possible I can just go over 2 questions of last week? Just 2.
Yeah, I think we can quickly answer it.
One thing you said last week about the garage and the carport, you said there's not a living area. I had many discussions this with the City of Cape Town specifically, and they've said it out and clear. Even if you build a carport or do you draw up a garage, that is seen as a living area. That's the one question.
And as a habitable area.
Yes, it's a habitable area. Someone can live there.
There I will guide you to what regulation AZ2 of the national building define as a habitable area, and that is not included in there.
Okay,
So
thank
when
you,
it
sir.
comes to building regulations, it will not be a habitable area. I'm not sure. It might be in terms of the SPLUMA regulations that for land use management purposes, they might see it as habitable areas. But in terms of the building regulations, it is not a habitable area.
Okay, thank you for that one. Something interesting with this last week was the changing of the windows. Let's say if you had timber windows and now change it to aluminium, you have to do a X-ray calculation for it. Now the question I'm asking now is specifically, say for apartments, if someone comes to you and says, listen here, I want to change all my windows, steel windows, now the one says the aluminium, does it still need an X-ray calculation? And to the same style, not a different style, different type of windows, the openings, everything must be the same. Also, the question is, who can, if you know by any chance, because I haven't seen it on the thing, who can apply to do that? In the sense that, can a draftsperson, technologist, or must it be architect who can do that?
Okay, there is a court case regarding if you do maintenance and you change material, you might even change it exactly the same size, but if the material are changed, because we sit now with regulation XA, and as Rudolf Opperman, when he was still with the NRC, is called it, it's an envelope regulation. So we changed the envelope. So the moment we touch the envelope and we change anything in the envelope and make it something that it was not before, then obviously we need to get approval for that. Okay. So that is the one thing that I just want to mention here. So there's a court case regarding that where the court have decided that because it's an envelope regulation, you change the envelope, then you have to comply with that. So it's only the envelope then, that section, that I believe then that you have to comply with. You do not have to comply with the other parts of the building because you only change the windows as part of the envelope. That's my interpretation of that. Who can do that? It's depending on if it's 1 or 2 windows, it might be a minor works, and then anybody can do that. If it's going to affect maybe fire resistance and all those other type of things in much bigger type of buildings, then I would suggest that you either satisfy then the work practice matrix in the IDFW or contact SACAP for clarification if you can or cannot do that type of work, if it may fall outside your scope of work and you're unsure if it will be deemed to be minor work or actual more detailed work.
Okay, totally understand. I'll contact SACAP just to get clarification. There's a question, something you said interesting now on the certificate of occupancy. You said, like for instance, most of the times when you apply for a job, they only give you the 4.1 to get the approved plans, but then they get their own guy to build a job for you, right? But then the guy does his own thing. Now, something which you said was, although you're not signed up to do the other stuff, it's almost like you're still liable for what the guy which they appointed. It's like almost like he's deviating from your plans, but you still it's almost like you're sort of still responsible for what the guy does. Maybe I misunderstood what you said there.
Can I answer that question just after the break when I deal with Form 1?
Okay, sure, no problem.
Okay. Okay.
Okay.
Last question, promise. That was the last question.
All right. Okay. Just be short so that we can take.
Okay, no, that's fine. That's fine. Tell you what, I'll give it somebody else. Fine. Sorry, I apologize. That's fine. I'll wait. It's fine. Thank you.
No, you can, since you're on the mic, you can continue.
Okay, so another question I'm asking is the power of attorney, right? You've explained perfectly. I understand what power of attorney is. You cannot. It's almost like if you sign something on the client's name which is not approved by you. But now the question I'm asking, there's 2 power of attorneys, right? There's one for the BDM, there's one for the LUM. So now the power of attorney, the reason I'm asking is it really necessary if you already have power of attorney of a job to need to apply for another power of attorney? If you understand what I'm saying. Because what you've explained to me is you're allowed to do this. So isn't that okay already, seeing that you have power of attorney on the BDM to just do the application instead of doing another power of attorney on the LUM?
Look, I believe that if the client gives you power of attorney and it's specifically stipulated in that power of attorney what you've got the right to do on his or her behalf, then one document is enough. It may be that certain local authorities, the certain departments have a prescribed form that they want you to complete. There's nothing in law to state, unless they've got a bylaw that states that you have to comply with that specific form. But the law doesn't state that you have to complete a specific form. The law states that let's say the owner in a document must provide or must then give you permission to act on his behalf as his agent, and give them specific, in that he must then specifically, and I think that's what we need to do. We must not get a general power of attorney, we must get a specific power of attorney. And in that specific power of attorney, what we are allowed to do must be spelled out by the owner, so that there's no arguments later on between the professional and the owner on, oh, but you have added that permission to do so, which might happen if there's a general power of attorney. So I would suggest get one is fine, and you can put in that power of attorney all the things that you need to have power of attorney for, and if the client have signed it, then that's fine. Then it means that they've given you that power of attorney. So that's not necessarily to have one for building control, for building plan applications, one for land use management, etc. If all of that is in one, you can just provide a copy of that to the different departments, if that, or have one or two signed, and give each one an original one. But it doesn't mean that you have to have a specific one for this and a specific one for that. If the owner decided to just do one and incorporate all of that in one.
Okay. Thank you very much. Appreciate it very much. Thank you, sir.
I just want to say I'm not a lawyer. I just done research on that, so I might be wrong.
Okay. I don't understand.
Thank you very much. We have, if I'm pronouncing your name very correctly, Betlida Potrika. You can come in, your mic is open. Then Dinell, Freddy there. Dino and Freddy.
Yes, good morning. It's Dino. Can you hear me?
I can hear you.
Loud and clear.
Yes. Morning, Mr. Decker. Thank you. Well, it's actually good afternoon already. Thank you so much for your presentation today. I appreciate your comments regarding SANS10400A and the requirements regarding Form 2s and training certificates, which were previously required with the first edition, but are no longer required with the second edition. And that is one of the,
I just want to correct you there. It was never, ever required. It was a courtesy if you have submitted that to the local authority, but it was never, ever required by any legislation at all.
Maybe not by legislation. Yes, fair enough. I do know Rudolf Opperman, when he first presented it from the NCRS's perspective, did recommend it. But anyway, definitely not required. So I agree with you. And that's one of the things that I present regularly in the presentations that I offer nationally. My two questions. Excuse me. Is there any engagement at higher levels, just as an example, perhaps between SACA and local authorities, that's trying to educate the municipalities in this regard? As I say, when I engage with professionals in my presentations, it's one of the most consistent problems that get faced at the front desk, so to speak. So is there any engagement at high levels trying to clarify that for local authorities?
Okay, I can't speak on behalf of SACAP, but I know that there are memorandum MOUs signed between local authorities and SACAP, and that there are negotiations taking place. But at what level, etc., I think we must get later on the registrar in here, maybe to answer those type of questions.
Okay. Second question, is there, so I was busy typing in the chat, and so I didn't quite hear one of your last slides. You were speaking about, oh gosh, when issuing a Form 2 or completing a Form 4, that you may be liable, but you used a specific word.
Okay. I think that is what happens is that local authorities do not submit back to us Section 4 of Form 2. Let me
Yes.
address that when I come to Form 2 after the break.
Yeah, it wasn't. Let me then rather ask the question, and maybe you'll understand. If so, for example, persons or professionals who are presenting XA nationally, and they issue training certificates to help the participants deal with a local authority, is there a risk or a liability in issuing those training certificates that are not actually required whatsoever?
Okay, unless you are registered and your course are registered through SAQA on the NQCTF, it's not a training course because there are specific legal requirements for training courses. It can only be seen as a CPD course in terms of the SAQA board notice. Okay, so therefore we have to be very careful what we call our courses. We can't call it training because training might be wrongly interpreted that it is recognized training. Unless you are registered, your training course is registered on the NQCTF via SAQA, it is not a training course.
Okay, so by implication, the certificates are essentially irrelevant.
Irrelevant, yeah.
Right, thank you so much.
I think, Mr. Manetsi, if we can take one more and then we can break for 10, 15 minutes.
Okay, yeah. Thank you, colleagues. Let's just have one. Then we can break for lunch. Derek, Angela, anyone, Fikile? JK is already gone. Yes. Anyone who is ready? Modwi? Stephen?
Hi.
Yes. Who is this? Yes, Stephen, you can go ahead.
I just wanted to ask, there was a statement, actually somebody asked how we going to get certificates, and then your response was, you don't give certificates.
Yes, sir. On SACAP, we don't give certificate on all our webinar that we provide CPD category 1. We don't give certificate. We allocate the points accordingly on your on the system. We don't give SACAP, we don't give certificate for CPD points. We only allocate. Yes, we allocate it on your points here.
I heard that.
So what you
when
can,
you explained, what I wanted to ask, because you came in before I finished the question. I wanted to ask, how do you then find out if you were allocated? Do you notify people, or do they have to go on the platform and check if they were allocated the points?
Yes, you check check on your system. You go on your system, you check there, you will see that we have allocated your points. If not, you can send us email to info or to Bezel. We can allocate, but we are going to use the register. This system does have a register that you attended, and we also requesting some random questions that we are putting in there, requesting your ID, even if you did not complete that question. But as long as you attended this webinar, we are going to allocate those points.
The one that we already did you already allocate, or you want to do the
yes, they are busy allocated. Some they've already allocated. If not, they are busy allocating those points here.
Okay, no, thanks. I'm answering.
So I think Mr. Decker, let's break for lunch, then we can come back. Mr. Decker, over to you.
Sorry,
Mr. Decker, over to, yeah.
I just battled to unmute myself. Yes, it's now 12:15. Let's break till 13:15 and then we can tackle the forms. Sorry, 12:45. 12:45 and we're back at 12:40. Gives us 30 minutes for lunch. So I'll start exactly 12:45 again. Thank you.
Yeah, colleagues, thank you very much. We still have got 1 hour, I'm sorry, 1 minute before Ms. Decker start, but when going through some of the questions that you wrote on chat, we are going to answer all these questions and submit to you. Some of them, they require our legal team to address those questions. And probably the one question that has been asked, which I just want to ask Mr. Decker to probably before he start SANS 400 form 1, is the issue of power attorney. Is a digital signature allowed? I'm sure there are. I was reading here. It's like four, 5 people have asked the same question, whether a digital signature is allowed on the power of attorney. But all other questions, we will compile them and provide the response. Then we can give you. Then the other question that it's about municipality. Does this apply to all municipalities? Just to give you comfort on that, what we did before we engaged Mr. Decker there are a number of municipalities that we are in partnership with who submitted all the referrals to us. Then we compare all the referrals that we receive from different municipalities, hence, which then give us this 4 sessions that we are having of referrals. So we received from a number of municipalities. With my little knowledge, I think it does apply to quite a few municipalities, simply because we did receive referrals from different municipalities. Probably Mr. Decker, before you start now, I'm sure it's he can address the issue of digital signature on power of attorney. Over to you, Mr. Decker.
Thank you, Mr. Manetsi. Yes, I quickly had to Google it quickly. Yeah, I know that there are restrictions on where you cannot use it, but in general, it looks like digital signatures are allowed on power of attorneys. What it says here is that in most cases, digital power of attorney is legally recognized. It's especially true in cases where it's not even necessary to have a written power of attorney. In our case, we need to have a written power of attorney. In South Africa, electronic signatures are governed by the Electronic Communications and Transactions Act 25 of 22, also known as ECTA, which then generally provides that data linked to or associated with other data may serve as a form of signature and will not be invalid simply because it's an electronic format. There are the requirements for specific things that you cannot do electronic signature. So it's not permitted to be used in executing wills or codicils, contracts relating to the alienation of immovable property, bills of exchange such as checks, which we no longer have, and long-term agreements for immovable property, which are in excess of 10 years. So it seems that power of attorney in electronic format is allowed, as long as you can trace the electronic signature. With other words, it must be done by something that can validate the electronic signature and not just a picture of your signature that you put on a form. So you have to use something like Adobe or any of the other applications that can create then a signature that can be traced to its origin. I hope that answered that question.
Thank you, Mr. Decker. You can proceed.
Okay, thank you. Then we carry on to Form 1. And what is Form 1? As I've already said, that Form 1 is a declaration that's made in terms of Regulation 821G. Remember, we went through Regulation 82, what is required to be submitted to a local authority. when you submit a building plan, and the last one was then G, which is then the declaration made with Edwards Form 1. That declaration must be made by a person registered in a professional category of registration in terms of one of the councils for the professions identified in the Council for the Built Environment Act. And if we read that together with the Architectural Profession Act, it implies that it is the registered architectural professional employed by the owner, as engineers, etc., cannot do architectural work. And I base this also, this is now coming from Part A, and I know there was a little bit of a debate on that, but I base this on the fact that in 2019, when this CBE published the scope of work for the built environment councils, the one for architecture say that we are the profession that are responsible for project coordination. So if we coordinate the project, then it means that we are the person that actually will have to make the declaration on how the different parts of not the 10 of the regulation are then going to be satisfied. Now, the completed declaration must set out how the applicable functional regulations of the national building regulations are satisfied. So it does not deal with the prescriptive regulations that's part of the national building regulations, but only those that are functional, with others, those that can be satisfied by using a standard or a rational design, then if you look at Regulation AZ4. So what we then declare on this form is how we comply with the specific requirements, or that we will require either with the specific requirements of the relevant SANS 10400 standard, or that we will do a rational design or an assessment, or both, if we are a competent person registered in terms of the requirements of Regulation A19, or if we are going to use then an Agramor certificate for the purpose of showing compliance. Now, it comes back to some of the questions that were asked. If we are employed up to stage 4.1, we are still having legal requirements to fulfill after that. And here you can see one of them is that the owner shall report any changes made after obtaining an approval, but prior to the actual construction thereof. We know that owners wants to change windows and stuff like that, but it is illegal if they do it and do not have permission to do so. So they have to obtain approval prior to the actual construction thereof. So the professional then responsible for the declaration must then obtain such approval from the local authority before the construction starts. It's a simple thing. We just go to the local authority, show them what needs to be done, make an amendment on the approved building plan or a note on the approved building plan in their possession, and then you get that. And if it means then that sometimes that deemed to satisfy have to change to a rational design or to the use of an Agramor certificate, then obviously you change Form 1 as well. You amend the declaration that you've made on Form 1. And then before those changes can happen on site, all these things then needs to be in play. Afterwards, just as a word, afterwards and before the owner then applies for the certificate of occupancy, all these little changes that happened in the meantime that you had to go and get approval for as the person who is responsible for the declaration on Form 1, you then submit an as-built. That is the only time actually that the word as-built is being used, is because as-built, it's as-built, but as-built with authorization to do so. If the owner continues with construction without making the changes, they are actually busy with illegal building work, and the opinion that I've got then is that a new building plan needs to be submitted and approval needs to be obtained from that. But because it's already built, it means now that you will have to go through the process of getting an assessment report by engineers, etc., for the work already done, because nobody checked it. It was not done according to the approved building plan. So it creates a lot of problems then for owners. And that's one thing that I think that we need to make owners aware of. Unfortunately, and that's my take on that, local authorities at the stage start allowing that, and they call it amendment plans or rider plans and all type of plans, which we do not find any of those mentioned in the regulation itself. So the regulations say you have to obtain permission prior to actually doing stuff, even if after you've got obtained plan approval, because otherwise you will be busy with illegal building work. Now, what is the declaration? The declaration is a written statement about something which you have signed and which can be used as evidence in a court of law. So if you have indicated on Form 1 that you're going to satisfy, let's say, part T via a deemed to satisfy, and it is submitted, and it's found then later on that it's actually not deemed to satisfy because you actually do not know the regulation, it can actually be used against you as evidence in a court of law, because then you have basically made a false statement, and false statements, as we all know, is criminal. To make a false statement, especially in the form of such a declaration, it can be then seen as a criminal offense. Further, that I've got on the definitions of a declaration, it can be seen as a binding identifier to values, and as the statement then is then carrying out the actions. So you make the declarations in that form, which is then the statement on how you're going to carry out the actions. To declare something, you actually make it known formally, officially, or explicitly. So Form 1 is not a checklist. Okay, if you want to have a checklist, you go to Form F1 or Form F2. Form 1 is not a checklist, it's a declaration, it's a legal document that you submit to the local authority, informing them on how you're going to satisfy the national building regulations. Okay, let's go then to Form 1. I want to click on that and just see, I've got two screens here, see which screen it's going to pop up. Okay, let me just move it over here. And I just want to make it a little bit bigger. So what I will do is although it is available on the SAP's website, as under the free document section of that, together with the presentation, I will provide SACAP also with this then, so that it can be circulated and that you have it. Now, on top of every form, you will see, and that's now from Form 1 to Form 4. You see that you have to complete the earth number, and I'm just going to just put numbers in there. Township, just going to put in Johannesburg. Owner, oops, sorry, let me just put in capital there. Okay, and then the date that you do the declaration, and nicely there you see that the forms that you can download from the SAP's website has got the same. So you can see you can nicely just select the date and you put it in there. Now what happens now is that on every page, if I scroll down, it automatically appears. That is a security measure in a way that's been brought in because with the older forms, unfortunately, people have started to take pages out, copy other pages, and put it in there. Now, what is the form then? As you can see there, it's a declaration on how the functional building regulations is to be satisfied in terms of Regulation AZ4. With other words, you're going either to follow the deemed to satisfy rules. You are going to do a rational design where you prove to the local authority that it's equal or better, or you're going to use AGROMA certification. And in this form, we do not talk about the 10400 series. We talk about how you're going to satisfy the functional regulation. So therefore, it starts off then with Part B, and if it's a new building, obviously you will have foundations, you will have floors, you will have walls, you will have fenestration, windows, you will have roofs, you will have maybe have a staircase or two. All of that forms part of the structural system of the building, and therefore, if you just click on that, you say that it's applicable. Now, quickly, I've just done something here just to quickly bring up. This is not what you get on the forms. That's just for my presentation sake here. You will see there what is the design requirement. Okay. And if we look at sub-regulation 3, you will see that sub-regulations 1 and 2 can be satisfied by doing the stuff in 10400B. So sub-regulations 1 and 2 here will then be your functional regulations. So we're going then to declare how we're going then to satisfy the requirements then of those two sub-regulations. And for this one, I'm just going to highlight, to read it quickly through for you. You're going to satisfy, when you tick there on part B, how a building and any structural element or a component thereof shall be designed to provide strength, stability, serviceability, and durability under all actions which can reasonably be expected to occur in accordance with accepted principles of structural design, and so that it will not impair the integrity of any other building. And secondly, going to declare that such buildings shall be so designed that in the event of accidental overloading, the structural system will not suffer disastrous or progressive collapse, which is disproportionate to the original cause. Now, if you do the deemed to satisfy, the deemed to satisfy of part B, if you go to the standard again, which I'm not going to do so, because it's part of the structural design, it will include then the deemed to satisfy rules of part H, J, K, L, M, and N. So if you do not at all, not going to satisfy any of those parts, any one of those parts by a deemed to satisfy, but by doing it a rational design, then you cannot tick deemed to satisfy here. You will have to tick then a rational design by a competent person, because that competent person needs to take responsibility for the complete rational design of the structural system. Let's say it's a simple single-story dwelling, and you can do the foundations as per part H, you can do the floors as per part J, the walls as per part K, and make sure then you do it against according to part L, K, the roofs according to part L. There will tend to be no staircases, but the glazing, it's not going to be higher than 10 meters in the wall. So if you follow the thicknesses of glass, etc., in your door and window schedule for structural purposes, then you're going to satisfy it for the deemed to satisfy requirements. Next, we move over to regulation C, which deals with dimensions. So what does the regulation they say? Again, sub-regulation 1 and 2 there will be the functional regulations. And it says that any room or space shall have dimensions that will ensure that such a room or space is fit for the purpose for which it's intended, and that the floor area of any dwelling unit, now dwelling unit can be in an H3 or an H4 occupancy, because that is what a dwelling unit is. Dwelling unit is then a unit comprising of a habitable room, including a kitchen or cooking facilities, as well as ablution facilities. It shall not be less than that necessary to provide one habitable room and a separate room containing toilet facilities. Well, it's actually saying it there then. So that is what you do then declare then when you tick then that you're going to satisfy regulation C. So obviously it is applicable in this case, and you're going to satisfy it by keeping with all the dimensions, etc., that are in the standard. Next, we move over to the regulation D, which is then public safety. And public safety, as you can see there under D5, the only functional regulations there will be D1, D3, and D4. So D1 will deal with changes in level. That is where you have to protect have to provide protection of the edge of any balcony, bridge, flat roof, or similar place, so that the person shall be prevented from falling from such a balcony, bridge, flat roof, or similar place. D3 deals with ramps. So a ramp or a driveway must be so designed that it's safe when used, and it must be fit for the purpose for which it's intended. And D4 then deals with the swimming pool and swimming bath requirements, which say that the owner of a site which contains a swimming pool shall ensure that access to the swimming pool is controlled. And D4 sub-regulation 1 is then actually the only functional one, because part 2 of that regulation is actually prescriptive, because it says that you will be guilty. So what we need then with swimming pools is to control the access to swimming pools. And we will do the standards later on, but you can actually see here it's not to do with the safety and safety nets. It's just how we deal with the safety of that. That is where we will then go to part D. Now, let's say in this case, there's not a safe swimming pool. It's a single-story building, so we do not have ballast canopies, balconies, etc. So in this case, it will be not applicable. The regulation F deals with site operations. Now, just for information, the regulation F is the regulation with the most sub-regulations. Fortunately, for the purpose of this, only a few of them are prescriptive. So that will be the parts that basically just refer to that you can comply with the different parts of 10400, part F then. And you can see the first one is where soil poisoning comes in. So the building shall be so required by the local authority, or in areas of high termite infestation, be protected from subterranean termite activity. So, and that needs to be done in terms of SANS 10124, which is one of 1, 2, 3 standards actually referenced by the regulations itself. The other one is then 10400 itself, and then 10005 is the other one. So when we deal with soil poisoning, we have to follow the rules in 10124 if we have to do soil poisoning. So if you are required to do soil poisoning, that is then what you have to go into click. Let's just quickly go through that. The other one where the standard is actually mentioned will be then for sanitary facilities, and it says that no owner or person shall, and that is the one that you can see there that can be satisfied through 10400 part F. No owner or a person shall commence or continue the erection or demolition of a building unless approved sanitary facilities for all personnel employed or on or in connection with such work have been provided or are available on the site. And if the facilities are not to be provided, the local authority may then actually order you to cease work until that is being done. So that is the 2 functional regulations that you have to tick on here. So let's say that you have to comply with soil poisoning, and obviously we'll have to comply with the sanitary facility provision during construction. So most likely those are the 2 blocks that is going to be ticked. Next we come to regulation G, that is excavations. And the deemed to satisfy requirements here will be then sub-regulation G11. So that first sub-regulation there will be then the deemed to functional regulation. And it said that where any excavation related to a building is carried out or is to be carried out on any site, and such excavation may impair the safety or the stability of any property or service, the owner of such site shall take adequate precautionary measures to ensure that the safety and stability of such property or service is maintained. And that is where 10400 part G then comes into play. that just a word of caution. Now it seems that my system is freezing here on me. I just want to stop that. Okay, I could have done that, and just have to go back to my form. Pardon for that. But we're with excavations. So yes, it will be applicable because there will be excavations. There will be foundations. There will be service excavations. And with service excavations, there is a specific requirement from how far from foundation excavations or existing foundation excavations that must be. So it's not just a tick box. Go and make sure that you know what is in Part G, because if you tick there, yes, and you tick there that you're going to comply with the deemed to satisfy requirements, and you run your services like sewer or water reticulation pipes, let's say 500 millimeters from a foundation, then you are not compliant to Regulation G, and you might have to do a rational assessment or a rational design by a competent person to ensure that there's no weakening of the foundation due to that excavation. So this is one that I think everybody just stick without knowing what is actually in Part G. Next one that we look at is Part H, foundations. And that's only got one sub-regulation that we have to comply with as a functional regulation. The foundation of the building shall be designed and constructed to safely transmit all the actions which can reasonably be expected to occur from such building to the ground in such a manner that any local damage, deformation, vibration do not compromise the efficient use of the building or the functioning of any element of a building or equipment within the building. So that's the functional regulation that we then click. So in most cases, we will be able then to do it with the deemed to satisfy rules that we have in Part H for a single-story building. Part H 10400, unfortunately, I've got also a section on that require you, or that it reads like that if you are required to do a geotechnical site investigation. Geotechnical site investigations, by the way, does not belong in Part H. We are busy after we've done an amendment to the standard. I myself have submitted a new work proposal to SAPS so that we can look at it together with the geotechnical guys, and I'm on one of the geotechnical committees as well. And we need actually there to go and look at what is in the prescriptive regulation F regarding soil investigations, and there are other legislation in place that require those to be there. So we are actually only required to use the data from existing ones. That is especially if we work in an established township, because the developers actually have to do so. So they are quite, at the moment, due to the misinterpretation and the fact that unfortunately there are clauses in Part H stating certain things that we are required at the moment, and in many cases just by default to do geotechnical site investigations where technically it is actually not required, but at the moment we have to deal with it like that, and hopefully the amendment will, the revision of that standard will happen quite quickly. Then we come to the regulation J, which is the floors. What does that require? And you can see there 1, 2, 3, and 4 sub-regulations here are then functional. It says that the floor must be designed and constructed to safely support its own weight and any actions which can reasonably be expected to occur, etc. It must have a fire resistance. There's a specific requirement that the floor of a laundry, kitchen, shower room, bathroom, and room containing a toilet pan and urinal must be water resistant. Suspended timber floors must be provided with adequate underfloor ventilation. That is now if you've got a single-story building with timber flooring where you have to have a crawl space below it, and where any concrete floor slab is supported on ground or filling. the floor must be so constructed that any moisture present in such ground or filling is prevented from penetrating such concrete floor slab. So those are the things then that we tick then here when we tick J that we comply with. And I believe that in many cases we can also do it as a deemed to satisfy, and we don't need an engineer in there because everything so far, simple building, we comply with the standard requirements. Then we come to part K, walls. Part K walls have got four sub-regulations that we then need to comply with. I'm just going to mention them. The first one deals with structural strength and stability. So there will be, depending on the type of masonry that we use, maximum heights, maximum distances, how we deal with openings and all those kind of things. So there's quite a lot in Part K that we need to make sure that we comply with before we can tick that box. Then the other one deals with water penetration. It goes about the construction methods, how we specify the wall to be built, especially when it's face brickwork, roof overhangs, and all those kind of things that has been mentioned then for how to prevent water from penetrating through the wall. That will also include then DPC, so that through capillary action, water cannot come from the ground. How the roof is fixed to the wall, quite important. A lot of people are so fixated with the fact that the roof must be designed properly that they forget that the roof must be fixed to the wall, and that is being provided for then in Part K. And we then also sign a declaration that we do comply with that. So what type of roof anchor are we using, an A, B, or C type, or are we going to do it according to a rational design? And then how is that wall going to behave in fire? When we deal with fire, you will see that there are three fire classifications for walls, F, R, F, and N. So did we take all of these into consideration? Did we look at cladding material and all those kind of things and see how they are actually going to behave in fire? So that is what we tick, and we say that we comply to when we click on Part K. Next, we deal with roofs. Now, the roof requirement, as you can see there, is, although there's two sub-regulations, the general requirement actually talks about two types of things that we need to look at. The first one is that it must safely sustain any actions which can reasonably be expected to occur, and adequately anchored against wind uplift, durability, and does not allow the penetration of rainwater or any other surface water to its interior. That's more an architectural function according to me, and that's where the old competent person built environment then came in, which can be an architectural professional, because we design the roof, we design the valleys, we design we specify the roof watering, to prevent water from penetrating the roof. We say what must be the pitch of the roof so that the accumulation of water doesn't occur on the roof. And it's also an architectural function to make sure that the height restrictions, or not height restrictions, but that the heights are complied with that we see in Part C. So that is the first thing that we then needs to make sure that we comply with before we can tick Part L as deemed to satisfy. And there are specifically when it comes to structural and to the others, you will satisfy deemed to satisfy, for instance, if there are no valley gutters, etc., and it's just a normal roof. Fire resistance and combustibility, a lot of that comes from Part T that we just have to make sure that we comply as well. So if we comply with those, we can tick then. Sorry, I think that is why it froze it. It asked me why my computer is doing this now. Let me just go out of this again so that I can go to the next one. Apologies again for that. We were with part L now. I just want to bring it back. I did when your computer tell you that your own files are sometimes unsafe. Okay, so that is what you tick then. Sorry, all the others are now gone, but that is what you tick then when you do roofs. Okay, I just want to go and tick that so that we've got an example here that is fine all the time. Sorry for this time wasted. Okay, so that's that. Then we go to M stairways. And although we do not have stairways in here, do note that M1 and M2 are the two functional regulations here. And if you go to part M, be very careful there to note that the deemed to satisfy requirements, especially in 0.3 and 0.4 and 0.5 of 10.400 part M, where you got deemed to satisfy solutions, well, actually, deemed to satisfy solutions for masonry staircases and timber staircases are only applicable to interior H3 and to H4 occupancies only. All other stairways, doesn't matter where you have it, etc., will be part of a rational design. So if I've got an office block and I use a timber staircase there or stairway there, I cannot use part M because the loads that are imposed on that stairway will not be the same as in a H3, H4 occupancy, and therefore it needs to be rationally designed by an engineer. The same for obviously reinforced concrete, or if I do masonry. So the main reason there is that the occupancy differed now and that the loads associated with that occupancy, more people, is okay. That also then means that if you, just as a word of caution here, if you convert a house, an H3, H4 into occupancy like B&B, that an assessment needs to be done of any stairway that are in that building, that any stairway that is in that building, so that the structural engineer can certify that it is designed in such a way that it will be able to sustain the loads that more movement, more people, etc., might then impose on that stairway. That's something that we not always understand, because we do not always comprehend what the regulation wants from us and how we then can satisfy the standard. So in this case, I've said it's a single story, so it will not be applicable. Okay, that is now gone missing. I'm not going to repeat that, but it was previously. Then we come to glazing. Glazing obviously is going to be in there. The glazing here is, although EXA is also mentioned in the new part N for glazing, but the regulation for glazing basically deals with the material and the way it's been fixed, and the selection then of glass, plastic, and organic coated glass material. So if that satisfies then the requirements of part N, then the glazing will obviously be applicable. Due to the fact that this is, the glazing here will never be higher than 10 meters from the surrounding ground level, we can use all the tables in part N, and normally that will be done, and that will satisfy then the deemed to satisfy requirements. Next, we come to lighting and ventilation. And I think here is where a lot of people do not actually satisfy the requirement. We do make declarations that we do. The only sub-regulation here that is functional regulation is sub-regulation 1. All the others are prescriptive regulations. With others, it needs to be complied with. So what does the sub-regulation 1, which is the functional regulation, require us to do? A habitable room, a bathroom, a shower room, and a room containing a toilet pan or a urinal, or any room which is a parking garage, shall be provided with means of lighting and ventilation, which will enable the room to be used without detriment to health or safety or causing any nuisance for the purpose for which it is designed. So we have to look at that 5% ventilation requirement, the 10% lighting requirement. You have to look at your zonal spaces. Do you satisfy the zonal space requirement, etc.? All of that is being covered in 10400 and Part O. And once you are sure that you do that, you can tick the box here and say that you deem to satisfy it there. Next, we come to regulation P. Now, drainage has got a few regulations to it. P1 deals with the compulsory drainage of buildings. That regulation, by the way, is a prescriptive regulation. Don't know what causes my computer to freeze up the whole time on this. I just want to go back there. See if it works now. My apologies again. Technology is one of those things that you can never trust. In tasks, open it again. I'm not going to fill in all the others. You've seen that. The video, obviously, fortunately, I've recorded that. So let's go back to Part O. Let's say if I say restore, no, it will not restore that one. No, that's not that one. So let's go to Part O. And Part O, lighting and ventilation will be okay. So what do I need to do to show that I comply with it? To satisfy, then to want a table on my drawing that show that I comply with the minimum ventilation and lighting requirements, the percentage of openings to the floor area, indicate that my zonal spaces are taken into account, and all of those things. Once I am assured that I have done that, I can click that. Then we come, sorry, that was lighting and ventilation. Then we come to drainage. Sorry, I was at drainage. So part P1 is prescriptive. P2, the design of drainage installations is deemed to satisfy one. It's meaning that when it comes to the design of drainage installations, from the waste pipe to the soil pipe, the vent pipe, the drain pipe, the connecting sewer, where I connected the sewer, septic tanks, conservancy tanks, French drains, a lot of requirements in that. If I am sure that I have satisfied all of that, I can actually click that I satisfy the deemed to satisfy. And there's quite a lot in there that we need to know of. So if you have to make use of, let's say, a French drain, note that you can't just indicate a French drain. There's a percolation test that needs to be done before the time. And then based on the data from the percolation test, the size of the French drain will then be determined. And in many cases, you might not even be able to do a French drain, especially if it's clay soil and stuff like that. And there might be additional requirements if you are in the dolomite areas, depending on the dolomite classification. Q, here we've got, let's say, waterborne sewer. So Q is for non-waterborne sewer. But I just want to show you the regulation. So the deemed to satisfy there will be sub-regulation 1, Q1, the means of disposal on how to do that. And if I satisfy all those requirements, if I have to do so, I can click that. In this case, it will be not applicable. Then stormwater disposal. It's a house, single-story house. Guys, it's not applicable. Ladies, it's not applicable. Why do I say that? Apart from the fact that we've got R1, that we can satisfy, then the R1, the owner of a site shall provide suitable means for the control and disposal of accumulated stormwater, and I can satisfy that via Part R. Part R, Regulation R2, to say that the regulations in this part shall not apply to any site exclusively used for the erection of any dwelling house or any building appurtenant thereto. However, the local authority can then, for every specific site, not in general, after they have given you reasons then why, require you to comply with the regulation R1. So it's not a given that you have to comply with the regulation R1. You need to be informed by the local authority with reasons why you have to comply with the regulation R. Then house is an H4. It's not applicable for persons with disabilities. But let's quickly look at the regulation. The applicable regulation there is not S1. S1 is prescriptive. You can't get out of that. You need to comply with that. So S2, which deals with the facilities that you have to provide, that is the one that you have to make sure that you satisfy if your building is an accessible building. In this case of a house, it's not accessible or does not need to be accessible, so we can say it's not applicable. Fire protection is applicable, but we have to make sure that we know which parts of regulation T1, which is the functional regulation, covered then in 10400 part T, and there is a new one out that we will look at next time, or in 3 weeks' time. There, it's blocked again. Just want to see if I do that, if I can go to it again. Part there. So part T, make sure that there are a lot of things that are excluded when it comes to house design. There's still a lot of requirements that authorities require people to comply with, where it is not even applicable to dwellings. And the reason for that is neither we nor the local authority are actually knowing our standards and what to do. And in many cases, a clause is taken out of context and requested for compliance. So we need to know what it is. So if for instance, the compliance with escape routes in a dwelling house needs not to be complied with. The only requirement there is basically that the garage door needs to have a fire resistance of 30 minutes. Even the new standard does not say that it must be a fire door. It says that it is equal to a Class E fire door, but it doesn't say that it must be a fire door. So there's a lot of things like self-closers, direction of opening, etc., that we then do not need to comply with. But it is applicable. We have to look at partition walls, wall classification, distance from boundaries, that is now notional as well as lateral boundaries. All those type of things that we must make sure that we still comply with. Space heating. Space heating is only to do with space heating. It's not to do with braais and stuff like that. So if you've got a chimney, etc., for space heating, then obviously we'll have to comply with part V. In this case, let's say that we do not have, but I just want to show you. I hope it doesn't break on me again. So it's any system of space heating in a building shall be so designed, constructed, and installed as to operate safely. And any flue pipe, or chimney used in such a system must be designed to safely remove any smoke or noxious gases produced by such a system. So you can't actually use part V to apply to chimneys for braais and stuff like that. It should have been taken into account with regulation T where it comes to fire protection. But if you comply with that, I believe in many cases that you will then satisfy also the requirements. Part W, fire installation, we do not have to have a fire hose reel or a fire hydrant in there. But let me just quickly show you what we need to comply with. We need to comply with the regulation W3, which is the functional regulation that gives me then requirements for the design of fire installations. So in this case, it's not applicable. Then we come to energy use in the building. Let's say that I, in this case, have complied with all the envelope requirements as given and the deemed to satisfy. In other words, I've complied with the floor, I've complied with the wall, I've complied with fenestration, I've complied with the roof requirements. Then while it is applicable, then I would have satisfied the deemed to satisfy way. It is technically because even if you've got up more than 60% fenestration, compliance with table 4, with other words, if you specify that your fenestration have to have a certain U and R value, then as U and what's the other value? S value that needs to be complied with, then you are deemed to satisfy. Okay, and it's up to the building control and the owner and the contractor to ensure that the windows installed in that building then complies with those values. If you want to specify a specific brand of windows, etc., you just have to make sure that the glazing, etc., that you specify in there, or in that is then in your window and door schedule, then make sure that you comply then with all of that. But that's a deemed to satisfy. Okay. If you are going to use thermal modeling software to show compliance to the energy consumption and energy usage in the building, instead of using the envelope, the architectural portion of the building then to show compliance, then it becomes a rational design. And that, ladies and gents, is then basically Form 1. Okay. So there's nothing difficult on it. The only thing that we have to remember here is that it requires us to, when we make our decisions, when we make our declaration, that we indeed, sorry, this thing doesn't want now to cancel, that we indeed satisfy then the requirements of the functional regulations by indeed do everything as required by the standard. Okay. Next we come to Form 2. Now we've already discussed quite a lot of Form 2, but Part A has got a little section in there to say why is Form 2 there. Form 2 is then a registered person appointed as the approved competent person. And we say registered because it must be registered with SACAP or with EXA or with the Scientific Professions Act. Appointed as the approved competent person by the owner in terms of Regulation A19 then shall apply to the local authority using Form 2 to be accepted as the approved competent person. And based then on the data that is provided in Form 2 and supporting documents, and that is quite important. People think that, oh, I just submitted Form 2, but you have to add your supporting documentation. You have to show that you are registered, so your registration certificate. You have to show that you've got PI, so your certificate of professional indemnity insurance needs to be attached. You need to show that you have done more or less a few of those buildings in the past. So maybe a little CV stating or a little list of buildings similar to that you've done in the past will be then assisting then the building control to make such a decision. So Form 2, the correct completion of Form 2, as well as the adding of supporting documentation to that is then required, so that the local authority can accept or decline to accept then the appointed competent person based on provisions. Those are those 5 things that I've read out earlier in terms of Regulation A19. The local authority then shall either accept or decline such application in writing to the competent person via Section 4 of Form 2. That is a legal obligation. It's in the Regulation A19. They have to complete Form 2 and complete that so that you are aware of the fact that you are accepted or not accepted. The mere fact that they might actually carry on and approve your building plans will, yes, in terms of legal terms, indicate tacit acceptance or tacit agreement that you are accepted, but you haven't got the written requirement, the written approval as required by law to be issued by the local authority, so that you can then, if something happens later on, have something there to manage your risk. And to be honest, your professional indemnity insurer might quite easily say, well, you've done a so-called, you've done a rational design, although you have completed Form 2 and submitted to the local authority, you did not ensure that you were indeed accepted as the competent person by insisting on getting Section 4 back. So we might, we might then, the insurance company might then decide to repudiate your claim and then use it with the drama and not, and the owner to deal with then in such a case, due to the fact that the local authority in the first instance did not comply with the law, and secondly, that you did not insist on compliance with the law. It's an administrative action, so if that administrative action is not duly done by the local authority, it's unjust administrative action, it is unconstitutional. The local authority does not, however, and this is something that we have to take note of, the local authority does not approve you as a competent person. They accept you as a competent person based on the information that you supply to them. So if you supply the correct information to them, you will then satisfy the required definition of a competent person, and there's no big story for them then to just to sign that section of Form 4 of Form 2, that is Section 4, Form 2, to accept you as the competent person, because they do it based on what you have submitted to them. If you have submitted wrong documentation to them and they have accepted it, then an error, well, you have created an offense in terms of the National Building Regulations. So let's look at Form 2. So again, there you can fill in everything there. This form is also one that you fill in. So what does you, so you can see there, it's an application for acceptance as an approved competent person. Okay, for the building, there's a declaration by the owner that he have approved, that he have appointed you to do a specific rational design, rational assessment, etc. And just like with Form 1, he also declared that he understands that he must inform you the moment he's going to change something, so that you are aware of that and that you can do the necessary then as the competent person. And you as the competent person then say that you accept that responsibility either via a rational design or a rational assessment or a geotechnical investigation, etc., that you accept the fact that you will provide the local authority with drawings, details and particulars as and may be required. You declare that you accept that you will notify the local authority in writing if it appears that the work is being carried out in a manner which might endanger the strength, etc., that your appointment is being terminated. You declare that you will submit Form 4 if required at the end, and you declare that you will maintain contact with the owner. Okay. So with other words, if you haven't made this declaration in Form 2 and you were not accepted then in terms of Form 2, you cannot actually issue a Form 4. That's what I tried to say. And there's quite a few other things on how you're going then to satisfy that. And then for each section, then let's say Regulation B, structural design, you basically then put your name in there. Say, let's say for instance, you accept that as the structural person. I'll just put in AAB there. I just want to show you to do. And the guys are not liking this. But remember, the competent person that takes responsibility for the structural system do take it not just in terms of Part B, but they take it in terms of public safety. There's a requirement there. For excavations, there's a requirement there. For structures, there's a requirement there. Floors, you can see there everywhere, because all of that forms part of the structural system. So that basically is per regulation then, that the person then fills in his or her name, and then you can see there every time there's a signature of the competent person and a signature of the owner required. Now, in this case, it cannot be done, according to me, via power of attorney, because there needs to be a contract between the persons, and the owner needs to know that he's appointed this person here. Okay. If you, as the architectural professional, do appoint those persons and you pay them, obviously you will be the owner and then you sign that, but that is not advised at all. So that's that. Now, what happens after you have been accepted? This is the section that the local authority have to complete. So they say, based on the information and the undertakings provided. So they don't have to go and do an investigation about your qualifications, etc. You provide all the information to them. They either accept you as a competent person or they do not accept you, and those are the 5 reasons that they can then use to not accept you as a competent person. Then the person signs it on behalf of the local authority, he signs it, he gives you that section back, or a copy of that section back, so that you have got record of the fact that you were accepted as the competent person. Just a few notes here, and that is just to strengthen everything here. And we've already looked at that. Regulation A19 requires the owner to appoint a competent person responsible for design, inspection, and assessment duties. To say that the owner shall, subject to the provisions of Regulation A19(4) and 5, appoint or retain 1 or more approved competent persons. And 3 say, where it is not possible, you have to inform the local authority and the owner shall appoint a new competent person to take responsibility for everything. Okay, then we go to Form 3. Now, Form 3 is a form that is sometimes not clearly understood. Now, what is Form 3? On the request from the person accepted as the competent person via Form 2. Let's say a structural engineer has accepted the responsibility for the structural system, and there's now a specialist roofing engineer that designed the roof. That competent person who have accepted responsibility in Form 2 will accept responsibility for the total design, and he must make sure that there's compatibility in the design system, etc. And he might even ask that component engineer, then, as I call it, to provide details to him, and he must make sure that everything works correct. And he may then request such person to submit to him a Form 3, with others make a declaration to him, informing him about his PI, etc., so that he has got recourse against that person if something happens. But he takes the responsibility. It's him that will be in the end to be responsible for Form 4. There's nothing like a roofing certificate. There's nothing like a foundation certificate, etc. All that is needed in terms of the building regulations will be then a Form 4. And remember that Form 3 is not submitted to the local authority. You will see now here, when I open it, and I'm not going to deal with that in detail due to time's sake. And if I can just draw it now over, okay, there is it. It's a declaration by a competent person appointed to design a component or an element of a system. With others, it's something like a third-party certification to the person who certifies in terms of Form 2 then that a system is working. Okay. And to who is it addressed? It's not addressed to the local authority. It's addressed to the person accepted in terms of Form 2. So that is administrative work between competent persons to protect the competent person that was accepted in terms of the Form 2 by the local authority. If subsystems are designed by somebody else. Okay. As I've seen now, it has been misused that architectural professional ask aircon installers to fill in this form, etc., or where a fan is being installed in a toilet where there's not a natural opening, they ask then the installer to complete this form. Now, that person is not registered with EXA. The architectural professional in terms of regulation 04 is not a mechanical engineer. He hasn't got that competencies as provided for by the engineering identification of work policy. So then it means then that that is being done wrong. Okay, so there's quite a lot of things that you have to declare. You can even go and do the inspection on behalf of the person that will issue Form 4 at the end. And based on this information, the person who has submitted Form 2 then can issue a Form 4 to the local authority. Okay, and then lastly, we look at Form 4. So Form 4 is submitted to the local authority by the person accepted in terms of the application made in terms of Form 2 as the approved competent person, certifying that the installation, the erection, or the construction of the building system for which responsibility was taken for has been approved in terms of Section 7 of the Act. Big issue here. Must the engineer submit their plans to the local authority? Somewhere in the A regulations, I can't recall now where it is, it said that the local authority may not want, may exclude the engineering drawings on submission for plan approval, but that needs to be submitted at least 3 days before that work is put into play on the site, and then it will be deemed to be part of the approved plan. So obviously those plans needs to be submitted, because you can't submit a Form 4 if those plans were not deemed to be then part of the approval in terms of Section 7 of the Act. And the accepted approved competent person takes then full responsibility for such installation, erection, or construction. It shall only be submitted to a local authority by a person who was accepted as the approved competent person in terms of an application that was made originally via Form 2. A local authority cannot ask you if you have made a declaration on Form 1 and the plan was approved as such afterwards to submit Form 4 because they couldn't do their inspections as required by the law. So let's look at Form 4. So this is a certificate of completion, and it says there to be completed upon the completion of the construction, erection, or the installation of the structural system, the fire protection system, the fire installation system, or energy usage, or any other as required by the local authority. Okay, but remember that is where a Form 2 was submitted. You can't now say because energy use is there that it needs to be submitted for energy use, and I think that is where people misread it. It's only where it is to be done where a person has completed a Form 2, and it is actually say here, for which I have taken responsibility in Form 2, to the best of my knowledge has been designed, constructed, directed. So if you haven't taken the responsibility in terms of Form 2, you cannot complete a Form 4. And if you do so, technically you're committing an offense, as I've said earlier, because then you provide a form under false pretenses because you were not accepted as the approved competent person. And that, ladies and gentlemen, basically right on time, 5 minutes brings me then to the end. Yeah.
Questions?
Okay, any good questions? Yeah, I just want to see. Can we just check? I've got echo in my ears, so I can't actually hear what I'm saying. Mr. Balexi.
Mr. Munetsi?
Okay, that's been fixed. Thanks, it's been fixed. I can hear myself now again. I don't know what happened now. I just want to check. I see nothing in the chat box, etc. Mr. Moletsi, if there are any questions on your side, or if anybody can open, I just want to see if I can see if you raise your hand. I'm not sure where to see it on the system here. If you want to ask a question, can I just ask you then to open your mic and just ask the question, if you can? Okay, there I see question and answer. I'm just going to...
Yes, colleagues, let me open for people for questions there. Let me start with Janet, Jacques, Velepi, Muyeni. Sorry if I pronounce, I made that your name. Okay.
The first one is Janet Francina and the other one is Jock Insulin.
Yes.
Hi, can I come in?
Yes.
Yes.
Perfect, thanks. I've heard that Form 2 only needs to get used when you do a rational design. So if you look at the second page of Form 2 at the bottom at E, maintaining contact with the owner of the project as to when my services may be required and declare that I'm competent to undertake the rational design, rational assessment, or geotechnical investigation. Should this form only be used then?
Yeah.
When you're actually doing a rational design?
Form 2 is only when you apply to be accepted as the competent person who will do then a rational design, assessment, or a geotechnical site investigation. Cannot be used for any other purpose.
So, okay, so if you're not doing a rational design, you don't ever have to then fill in or submit a form 2.
Then you don't submit a form 2, yeah.
Okay, thank you.
Okay, thank you. Jacques, you can come in.
I think I've just spoken to Jock.
Oh, okay, Janita, Francisca. Okay, let me allow others. Well, is this one they are unmuting?
I can go quickly.
Yes, please come in.
Thank you. This is Panina again. I just want to ask a very quick question. Does the competent person who has signed the Form 2 and all is in order with regards to the owner's signature, etc., do they have the, with this Form 2 in place, and all is good, site has progressed and gone ahead, work is underway, if a structural engineer has signed Form 2, does he have the right to cease all works on site? Thank you. Please advise.
It will depend on the way the building contract has been established. If there is a professional team that do project contract administration, with other words, if there's a principal agent, etc. If everything was done up to stage 4.1, his requirement is then to notify the local authority that the work is not done according to his design, and that it might then later on lead to an unsafe building, etc. And it's up to the local authority then to act on that, because the contractor will and the owner will then be busy with illegal building work. So the requirement is that he or she must inform the local authority that they are indeed not satisfied with what's actually going on the construction site. But it all depends on the type of contract. If that's a decent contract and everybody is appointed up to stage 6, it will be technically handled at the site meetings, and then obviously it will be dealt with there. But if it's up to 4.1 only, and the contractor don't want to adhere to instructions, because he can still give instructions according to me after inspection to say that it doesn't adhere to his design, then he can inform the local authority, and the local authority has got then the duty to intervene then there.
It's actually, in this particular case, I'm speaking on behalf of somebody that I know is in this particular scenario but couldn't join this talk today. Mr. Decker, thank you for your answer. But it's actually the owner and the contractor are abiding. It is found that the actual Form 2 competent person has been found that his drawings are not in order.
Okay, then it's a case that it needs to be reported in terms of code of conduct to the Engineering Council of South Africa. That's all that I can say here. Okay.
Thank you, sir. Thank you very much. And thank you again on behalf of all the listeners today. I'd like to just say thank you so much for this incredibly informative presentation. Thank you, SACAP, as well. Thank you, Mr. Decker.
Okay, my pleasure.
Thank you.
Hello.
Yes, come through with this one.
Hello. Hector.
Yes, Hector.
Yes. Thank you, Chair. Mine is just a small question for Form 1. Under persons with disabilities, I think I've been having internet problems and connectivity. So I missed why is it not applicable again?
Oh, it was not applicable because remember the example that I've used was an H4. Regulation S1 states that Regulation S is not applicable to H4s at the moment, okay? But nothing prevents you from actually adhering to it, but it is not required by law that houses do have to comply with Regulation S.
Okay, thanks, Frans.
I'm just stating that I am the chair of TC 59
Hello.
Subcommittee 4, and that we are actually looking at standards in future for that type of that we can follow then as a code of practice to ensure that we can actually quite easily design then the housing also for that, although it is not required by law as yet to do so.
All right, thank you. And then my last question.
Decker.
Sorry.
Good day, Mr. Decker.
Yes, Mr. Moadine.
Mr. Decker, if a plan had been approved and the building had been completed, and now the local municipality asked for Form 4 to be signed, but there was no energy efficiency report handed in with the submission of the plans. What do you do in this case? Do you, since the plans has already been approved, should you now give a Form 2 to the client as well with the energy efficiency report, and then sign off if it's in compliant with the approved plan? Should you then sign the Form 4? Is that legal?
No. Your declaration in Form 1 will determine if a Form 2 needs to be issued or not, okay? If during the process of construction, the owner informs you that he's going to change the way that you have designed the building, and you found out now that it needs to be a rational design because you can't satisfy it via the deemed to satisfy, then before construction takes on, You go to the local authority, amend your Form 2, provide them with the necessary details. They are supposed then to give you, let's say, temporary permission to carry on until the building is completed, and then before you apply for the certificate of occupancy, you do an amended plan or as-built plan, but then when you do the temporary amendment, etc., then a Form 2 should have been submitted, because they can't accept that changes and approve those changes without a competent person. And then in the end, they can only ask for a Form 4 to be submitted to them. But if it was done, no changes, and your Form 1 said that you do it via deemed to satisfy, no changes happened, and it was indeed done like that, it is deemed to satisfy. And you do not, and you haven't submitted a Form 4. So if you are then requested to submit a Form 4, that is an illegal request. It's an unlawful administrative action. It's against the national building regulations, because you can only submit a Form 4 for a rational design, as earlier said.
Yes, I just want to be quite clear, Mr. Dekker. So if no energy calculations was asked for in the first place, a Form 2 has not been signed, the municipality cannot come afterwards if the plan, if the house was built in accordance with the approved plan, they cannot come afterwards and ask for a Form 4.
No, they can't.
They
That was
can't.
one of the reasons why the second edition of XA did away with reference to SANS104. Because in the past, when you had to do your fenestration calculations by using SANS104, you've used another standard to show compliance, and then you had to submit a Form 2. Today, we use Table 4. Table 4 is a deemed to satisfy. So you do not have to do any calculations anymore. So if it's done under, especially under the second edition of XA, and you do the building envelope requirement, satisfied via the building envelope requirement, the chances that you have to submit a Form 2 for a rational design is very slim. And I just want to put emphasis on them again. No Form 2 required. You cannot issue a Form 4, because then you issue something that you were not asked for. So it is like you're going to a motor dealership to have your motor service. You agree that this and this is going to be done. Then when you come there, they all also say to you, you know, they found out that the color of your car was not to their liking, and they repainted the color of the car. Now you have to pay for that as well. That's the same principle. So it was not required, so therefore they can't ask for that.
Thank you for that information, Mr. Dekker.
Okay, thank you very much. Okay, I think, Mr. Benetzi, it's not already 10 minutes past 2. I think
Frans?
we can. Yes.
Hello. Yes. Sorry, Frans. I've had my hand up a while. Just one quick question. On Form 1, our municipality is requiring that the engineers, should we be using a glass balustrade that engineers sign for regulation B, D, and N? Now, with the B and N, they don't have a problem. But with D, our engineers seems to have a problem. Why should they have to take responsibility for public safety?
Because a balustrade, the barrier is public safety. A barrier is required in terms of Part D. The structural requirements of that barrier is then in Part B, and Part B, because it's glass, also referred to Part N. So the main standard for a barrier is not B or N, it's actually Part D.
D, okay. Okay, so the engineer at the end of the day does have to sign that as well. Okay,
I have to
just
sign
checking.
it off, yeah.
Okay,
That's
thank you.
correct. Okay. Just by the way, on those 4 balustrades, the only balustrade that do not need an engineer to sign a Form 4 to take responsibility for the structural requirements is a wall done in terms of Part K. All other balustrades, timber, steel, glass, etc., needs to have, in terms of Part B, a rational design done, and after completion have to have a soft back impact test done to determine that the installation was done correctly and that it actually satisfied the safety requirements for impact, which is totally ignored in many cases by a lot of people. So what I want to say is if you've got a balustrade or a barrier as we call it now, you need a structural engineer.
Hello, can you take my call? My question?
Okay, I think is it Mahir Abrams? That's the last one
That's
that
me.
I can take. Unfortunately, I have to go after this.
Sure, thank you. Okay, so I've had some internet issues for the last 15, 20 minutes. I just wanted to know firstly if I can have access to the presentation that you were going through, Form 2. I think the Form 3 and Form 4, I got the gist of that. And then with regards to Form 2, did I hear correctly? You said that only if you if you don't deem to satisfy requirements, then you do, at least if you do that, you don't have to supply a Form 2 to the municipality.
No.
And then
If you satisfy the deemed to satisfy requirements 100%, with other words, you do not do a rational design in terms of Regulation AZ41B2 or the others that are mentioned in Regulation A19, no Form 2. And if you do not have a Form 2, that also means that there's no Form 4.
Okay, is the municipality aware of this? Because on multiple occurrences when I submit my documentation, and we if I can say 99% of everything is deemed to satisfy requirements, they request a Form 2 per appointed professional.
I think, you know, there's an old saying, ignorance of the law is not an excuse. So there's no excuse for the local authority not to know the law that they are mandated to administer on behalf of the minister.
Fair point. But yeah, so
and sometimes we have to educate. Yeah, sometimes we have to educate them and show them. And I believe that, and I think the registrar will pardon me to say that if you've got any problems with local authorities persisting in this, contact SACAP and through the registrar, etc. There are communications in place that that can be rectified in future, hopefully.
Okay, that's great. Thank you very much.
Mr. Manetsi, I believe, okay, I will provide you with the PDF of this presentation as well as the forms during the course of today, tomorrow's, so that you can check it out. And I believe it's also on YouTube. Mr.
Okay, I think we're done. Okay. This was indeed a highly informative session. It is in that manner that we wish to thank Mr. Decker for sharing his expertise. We once more wish to thank everyone for their participation and availing yourselves for these sessions despite your hectic schedules. As alluded earlier, this was the second session, and we thank you in advance for availing yourself for the next sessions, which will touch on national building regulations and SANS10400 structural parts BH, J, K, L, M, and N. The third session will be held on the 8th of May 2024 from 10 o'clock to 2 o'clock. Please note that the SANS10400 and the presentation, as alluded by Mr. Decker, will be shared with all the attendees, and the video will be made available on YouTube channel. The channel page is We Are SACAP. You can go to YouTube and search We Are SACAP, and please subscribe to our channels to access all our recordings. In closing, Mr. Decker, thank you very much for your time and your insight. We declare this webinar closed. Thank you very much. Thank you.
Thank you very much. Colleagues, you can, before you log out, make sure you complete the questions for your CPD points. Thank you very much.
This one was very informative.
Going over.
But I think you helped a lot, hey?